Test, test. Can anyone hear me?
Yes, good morning.
Yes, yes.
Okay.
Hello, good morning.
Oh.
Good
Hi.
Good morning.
Okay.
Hi, Thomas.
Hi, Andrea.
How are you
Hi.
today?
I'm fine. I think it's better because I hope there will be no any technical problem today. So I think it could be better because, as you know, yesterday our start has no, it was not at the time which was should be. So I think today will be, better. And so we have foreign session today. I hope we share a regulation from different countries. As I said yesterday, we have one change because ladies from Ukraine said that they could speech their paper. So 9:30 will be other different speech from Poland. But I think the rest of them will be okay. So welcome our guest from Georgia, from Romania, and I can see anybody from Portugal, but they are at the end, as I remember. Yes, so I hope that they confirmed. So I hope they will be at the time they should. So let's start the first panel. The first panel named Zamówienia publiczne i roboty budowlane w Ukrainie i w Gruzji, public procurement and construction works in Ukraine and Georgia. So it will be in Georgia, but ladies said that they would write their article. So I hope we will know something about Ukrainian regulations too. So Simon and Georgie, your floor is yours from Sultan Saba Orbeliani University in Tbilisi, Professor Simon Takashvili and Georgie Mechadishvili, PJ student. Their paper zakres odpowiedzialności wykonawcy, pracownika za naruszenie umowy o roboty budowlane w prawie gruzińskim, the scope of contractors, employees, liability from breach of construction contract under Georgian law. So dear friends, floor is yours. 30 minutes because you are both of them. 30 minutes, please, welcome.
Hello, everyone. Good morning. So I can share the presentation.
Okay. Do you know how to do it?
Yes, I will try.
In the right, top right,
yes.
you have I don't know. You have English version and Polish.
English version.
So there is share.
Yes.
Should be share. And there should be screen.
Yeah.
Not window.
Yes.
Share screen.
Do you see my screen or not?
Yeah. No. Your. Oh. Here you are. Yes.
Yeah. So thank you for joining me today. I am thrilled to be here to discuss the scope of contractors' employees' liability for breach of construction contract under Georgian law. As it mentioned, I am Simon Tagashvili, Associate Professor at Sultan Saba Orbelian University, attorney at law. I am with my PhD candidate, Georgi Chedlishvili. As we mentioned, we will present the general approaches of Georgian legislation to the contractor's employees' liability for breach of construction contract. The presentation is divided into two parts. The first one is related to the general regulation of the construction process and the liabilities of the contractor and the Civil Code of Georgia, because the Civil Code of Georgia is the main source of the construction contract. The second part of the presentation is dedicated to the public construction process and the state procurement. The second part will be presented by Georgi and the first one by me. The legal issues related to the process of performing construction process and the contractor's liability are very specified in Georgia. And it's very interesting, and there is a prevailing practice of Georgian Supreme Court. Of course, when we draft the final version of the article, which we will send you, there will be many cases which we have in the Supreme Court of Georgia. The Georgian legislation regulates the relationship between the contractors, employees, and the employer. But there are some problematic issues which might be arising in practice. The present article and the present presentation analyzes the grounds for the contractor's liability and the impact of the construction process. So, as I mentioned, the general scope of the construction contract is the Civil Code of Georgia, which is very strict for the client. Article 629.1 states that under work contracts, the contractor commits to completing the specified tasks outlined in the agreement, while the client agrees to pay the contractor the agreed upon compensation. As for the state procurement process, the contracts, they are regulated by special law, acts which are very specific and define the scope of the contractor's liability. So we have there's a separate part of the state procurement, but the main source of the construction contract and construction process is the Civil Code of Georgia. As for the state procurement, Georgi will present this section. Contractor's obligation under Civil Code. It's the biggest topic in our presentation. Georgia legislation stipulates the general principles of the contract, which states that the general contractual obligation is that a party to a contract must perform the relevant obligation exactly as it stands, no more and no less. It's a general rule in our civil code. I think that it's also a very general rule in all around the world, including your countries. The civil code is very strict to the contractor and stipulates that a construction is legally free of defects if third parties cannot assert any rights against the client. Also, a construction is considered free of material defects if it meets the agreed upon conditions. If no such conditions are specified, the construction shall be deemed free of material defects if it's suitable for the purpose outlined in the contract of the ordinary use. A material defect is also considered to exist if the contractor produces an different article or item, for example, different from what was ordered or in a smaller quantity. The second sentence of the Civil Code is very strict, and there are many cases in the Supreme Court of Georgia. Of course, as I mentioned, we will indicate all cases, all interesting cases which might be interested for you and in order to publish the article. As for the remedies and contractors' liabilities, which we have under Georgian Civil Code, the Civil Code of Georgia stipulates the liabilities of contractor if the construction is defected. You know that sometimes the construction process is very defected and the item is defected. So the client may request additional performance. So the first things which the client demand is that the client may request additional performance. The contractor may choose either to remedy the defect or to produce a new construction. For the purpose of additional performance, the contractor is obliged to cover the necessary expenses, including transportation, labor, and materials. But there's some issues as well. The contractor may refuse additional performance if it would require disproportionate expenses. Sometimes the expenses are very disproportionate, and it means that the contractor can refuse to charge the expenses. There are some cases in Georgian Supreme Court, and it's very problematic in Georgian reality. Also, the client is entitled to demand the damages, and damages is very, very interesting in Georgian law. The purpose of compensating the claimant for the fact that he or she has not received the performance concluded by the parties is undoubtedly the most important. In general, and especially in construction contract, a breach of contract always entitles the innocent party to nominal damages. But in Georgian Civil Code, the client cannot demand the moral damages, for example, because moral damages is very specific damages, and under construction law and construction relationships, the client, the contractor can only demand the damages which might be in the financial damages, not moral damages. Under breach of construction contracts, the client is able to demand financial damages from the contractor. Presumptively, the burden of proof is on the claimant to prove the existence and amount of any financial losses she suffered. It's also very important because the burden of proof is on claimant. Claimant is obliged to prove the legality and the demand the any financial losses, but this demand might be grounded in order to satisfy its claim. Lost profits is also very interesting in Georgian Civil Code. Lost profits is always linked to the construction process, because sometimes the construction process denied, and it means that the contractor or the employer is able to demand lost profits. Under breach of construction contract, the client is able to demand lost profits as well. So our civil code is tend to demand the claimant lost profits. The Georgian legislation and the Supreme Court of Georgia is very strict towards the client, who is obliged to prove that the aim of the construction was to rent or to sell the property, but because of the breach of contract, she is unable to receive the income. So the burden of proof in this case is on the claimant. Claimant is obliged to prove that he or she wanted to rent the construction, for example, or some kind of to receive any kind of profits, which he or she is unable because the construction process is not over, is not finished. There are several cases of the Supreme Court of Georgia which say that the burden of proof is on the client. She is also liable to prove the amount of the lost profits. It's also very interesting in Georgian Supreme Court practice and in Civil Code of Georgia, because the burden of proof of the amount of the lost profits is also on claimant. I don't know how it's in your country, but in Georgia there's a strict rules for the claimant in order to prove the amount of the lost profits. So it's very problematic, and we will try to indicate all important issues in the last version of our articles, which will be published. As for the dispute resolution design and the Georgian law, it's also very conservative, as I can say that if the dispute arises from the civil cases, for example, the construction projects, the competence of the dispute resolution has a court and arbitration. Historically, disputes in the construction industry were resolved through litigation or arbitration, and this remains common practice today in Georgia. But sometimes in the big construction projects, in my practice, I can say that the arbitration is more relevant because arbitration is very flexible under Georgian law, and the employer and employee always try to reduce your risks and to make some arbitration agreements in their construction contract. If the dispute or difference arises in the construction relationship, the parties have to refer it to the agreed arbitration, and also we need arbitration agreement in the construction contract. Otherwise, it's for example, the client, contractor, or employee or employer. It doesn't matter which party is not able to go to the arbitration, because if there is no arbitration agreement under Georgian legislation, the claimant is not able to go to the arbitration. Accordingly, the main dispute resolution source in this situation is the court, and the claimant can go to the court and demand the financial damages, as I mentioned above. Accordingly, if the parties agree to arbitration, the national courts usually lack jurisdiction. So it means that if we agree on the arbitration, it means that we should go to the arbitration. Otherwise, the court has jurisdiction. So its general scope and general employers and employees' liabilities, which are stipulated in the Civil Code of Georgia. Now, as I mentioned, Georgi will continue the presenting, and we can understand how the Georgian state procurement organized and regulated by Georgian legislation. And Georgi will continue these slides. I will help him in order to present.
Hello again. I want to talk about the general principles of construction contract in public law. First of all, attention should be focused on the practice to the contract. The attention is focused on Article 3 of the law on public procurement, in particularly on the circle of persons who are the implemented of state procurement, for example, the state or administration bodies, represented automatic republics, legal entities of public law, other legal entities that has a 2/3 of project implementation budget for the state sponsored. As for the contract, it can be a legal or entrepreneurial implementation who meets the tender requirements in terms of the experience and personals. So rights and obligation of the parties in general here is the issue is the problematic, because since the case is about public procurement, even by participating in the tenders, the contractor has to agree to the tender condition, which of course worsen his legal situation. For example, to start the project, the contractor must check the design departments, which is associated with difficult to implement in parties, especially when it is comes to the construction of the highways. Because of the work on the place must start in 3 or 5 days, which means occurrence of a number of enforcement circumstances, new agreements, and daily in the work. And each new agreement requires more time, which significantly complicates the pace of work implementation. Next one, please, Mr. Simon. contract. So talking about the contract responsibility is difficulty important, which is responsibility for the violation of the project deadline, which is caused by a number of factors, especially the communication between factories to the contract changing project, and this time winter is coming or meteorological conditions are getting worse, at which time is the difficult to work at a piece or even to produce materials, which leads to delay in deadlines. So the quality of works, which is any other activity issue and is often caused by not by the dishonest action of the contractor, but by importantly implemented pre-designed works, which means that the contractor don't have real information about what kind of work or what will be in contract in which sentence. So the warranty period, during which the contractor informs the contract about any violation, and if in the short time that is determined in the practice for correction and for the violation of the deadline, there are sorry, please come back. There are various sentences, but the dedicated defect is often due to increased design work or previous design works and not because of the contract. Please now. And as for the grounds of the liability, this is a very topical and problematic issue in our country, where in the draft of the public procurement contract, it is indicated that the contractor will pay 5 times more for default interest than the contractor, and for a number of other small default interests that are not in the contract with the customer at all. In particular for breaking the default interests. And I want to talk about also Georgian court. In one of the cases, the Support Court of Georgia has established that the imposition of default interest should be aimed at the compensation of damage and not the enrichment of the customer. Thank you, and we looking forward to your questions regarding this topic.
So, as we mentioned, I will try to.
Ready?
Yeah. So, another part of our presentation and the another issues will be indicated in our article, as I mentioned, which will be submitted by us at the end of the December, as I remember.
Oh. I will write email today or tomorrow, so there will be some details about this.
Okay.
Thank you very much for your presentation. Very interesting. Maybe we change our program, because we have debate at the end, but maybe we will do some eventual questions after the panel. So because we have only one speech from one paper from in this panel from abroad of Poland, of course. Maybe someone has questions to our guests. Maybe to Mr. Simon and Mr. Georgi.
Hello again. And
Hi,
excuse me,
Andrea.
I do have a problem with the sun today, not yesterday. Today is larger. Okay, so
With sun?
With the sun, yes, it's too much sun in Romania. I don't know.
Wow. You are
We are not-
happy.
We are not.
Sun.
It's not problem.
Yeah, it's a lot of sun. I cannot show it to you, but it is a problem for me because it's always in my eyes. So I try to change the screen in order to see you all. And
Okay.
temperature in Poland is around 3 or 5 degrees. So.
3 or 5. No, it's also cold here, but the sun is there and is doing his job very well today.
Without sun. Okay, please, Andrea.
So I do have a question, a technical question for Professor Simon Takashvili. If I pronounce okay, if not, I ask you to your excuses. You were talking about the burden of proof and about the jurisprudence of the High Court of Cassation in Georgia. Do you have in the specific legislation a norm or a text or a provision of the law where the burden of proof is fined, or you have this text only in the civil code? Because you were talking about two laws, and I'm interested if the legislator in Georgia was interested to present this burden of proof, which I think is the most important thing in this kind of litigation, in the special law, or you only use the civil code, because we don't have this in a special law.
Okay, thank you very much for this question. It's a very interesting question. We have two main sources of legislation, or two main sources of legal act. It's the Civil Code of Georgia and Civil Procedural Code of Georgia, which stipulates the general principles of the burden of proof. Both of them stipulates that when the claimant starts the proceedings and files the lawsuit against someone, including in construction disputes, the burden of proof is on the claimant, especially in the business disputes. But there are some issues which says that, for example, in the employment contract, labor contract, and the burden of proof is on the employer, who is obliged to prove, for example, the legality of dismissal in labor law. But in general, as I mentioned, we have the two main legal acts which are regulated, the construction process and the dispute arises from the construction process, and the burden of proof is the Civil Code of Georgia and the Civil Procedural Code of Georgia. And when we start the litigation process and we file the lawsuit against someone, for example, if we are the employer or the contract or the client, which should receive the item or the construction process, and the contractor breaches the duties, we start and file the lawsuit, and we know that the burden of proof is on our side, and we should prove the legality of the, for example, if there is a financial damages, for example, the amount of damages, and etc. Yes.
So thank you very much. That means you are in the general rule. You don't have special rules in the burden of proof in this field of public procurement. Okay, thank you. It's the same to us.
Okay.
Yes, the same in Poland.
Okay.
We have general rules about burden of proof, so any special rules in procurement in Poland. Okay. Has anyone questions to our guest from Georgia? Any doubts? Any questions?
If we are talking about electronification, as you said, you named your conference, I would be interested if there is any electrification in Georgia.
In Georgia?
Yeah,
Okay.
in this field of public procurement, administrative proceedings.
Yes, it's in the public procurement process is totally electronical.
All of it?
Yes.
Everything is online?
Yes, it's in Georgia. Yes. Yes.
Okay.
And it's very transparent. Frankly speaking, it's very transparent. because everyone can open the special website of the state procurement agency and can see what is happening, for example, one construction project, and what are the documents, what are the contract, and who are the parties of the construction process, and so on. So it's very transparent.
But after proceeding or during proceeding?
Yes, during the proceeding, we can see the so we can control and monitor the construction process and the documents which might be drafted during this period.
But only participants in procurement or third parties?
Third parties are also came to see this. Yes, it's transparent.
That means if you have an account or anybody in a free way, you do have to have an account in this program, or
yes. No. There is a special numbers of tenders, for example, and you can open the website and indicate the special number of the tender, and you can see every document which drafted and concluded between the parties. You can see, for example, the amount of the money.
But after proceeding, not during proceeding.
As I remember, Georgi will help me. As I remember, it's transparent during the whole period.
Everyone knows the price, for example, offered by
confidence of the technical
participants.
Yeah.
I don't think so.
Yeah.
So very
not all the things. I have a company. We are contractor of the government, and they have any details for us. Our numbers, any money they spend us, when, why, and many details. Why we need more time? Why we make a change? What was it? Details.
Yes.
And,
But
I
the
know how
financial
it
offer,
feels.
do you have the financial offer in this program? And everybody can see the financial and the technical offer,
in
because
this
you have a
country, everyone knows
competition there.
my number.
After choosing, for example, after choosing the offer, I think. Not before.
No, there's a public tender. So I will explain. There's a public tender where everyone can submit their offer. So when someone concludes the agreement, final agreement with state procurement agency, everything financial issues, construction
I understood now.
Yes,
I understand now.
Yes, should be included. And it's public.
As I understood first, it was that all when the administrative proceeding is pending, everybody has access to it, but that's
no.
I understood the same way. So
it's the same in Poland.
Yes. Poland is the
in
same.
Romania too. We have the same site.
It would be very strange if everyone could say offer.
No. I did not mean this.
Okay, thank you. Okay, any questions?
Any other?
So, thank you very much, Mr. Simon and Mr. Georgi. And we have the change, as I said, because of ladies of the Ukraine. So the second paper will be the paper Mariusz Ciosek, naczelnik Wydziału Zamówień Publicznych w Ministerstwie Rozwoju i Technologii, and her paper, certyfikacja wykonawców zamówień publicznych, Certification of Public Procurement Contractors. Jak widziałem essay, so Mr. Ciosek is with us. Have you presentation? Yes, okay. Yes,
hello,
from
ladies
our
and gentlemen.
ministry, floor is yours, please.
Yeah, ladies and gentlemen, let me speak in Polish because I didn't know that conference would be in English, so I'm not fully prepared. So I would like to say sorry for it, but I didn't know. Okay, so my presentation is in Polish. Rozumiem, że możemy zaczynać, tak? Chciałem Państwu krótko opowiedzieć o certyfikacji wykonawców zamówień publicznych, nad którym teraz ministerstwo pracuje. Jest to certyfikacja, jest to rozwiązanie dedykowane przygotowywane z myślą o MŚP. Zostało ono ujęte w polityce zakupowej państwa, gdzie wskazano, że zamówienia publiczne staną się instrumentem wspierania MŚP poprzez zapewnienie szerszego dostępu do zamówień, usunięcie pewnych barier, które w dalszym ciągu w pewnych zakresach funkcjonują. Taką jedną z barier zidentyfikowanych jest pewna nadmierna ilość kwestii formalnych związanych z ubieganiem się o zamówienie publiczne. Dlatego, wzorując się na innych państwach członkowskich, postanowiliśmy wprowadzić do polskiego systemu certyfikację wykonawców. Certyfikacja generalnie polega na tym, że wykonawca zamiast przechodzić szczegółową weryfikację w toku poszczególnego postępowania o udzielenie zamówienia publicznego, przechodzi taką weryfikację przed wyspecjalizowanym podmiotem, to znaczy podmiotem certyfikującym. Po przejściu takiego procesu, w trakcie którego weryfikowana jest jego sytuacja, otrzymuje certyfikat, którym może się posługiwać później w kolejnych postępowaniach już poszczególnych, aby wykazać swoją sytuację, swoje zdolności. Tak? Więc jest to w pewnym sensie odejście od takiego modelu weryfikacji wykonawcy na gruncie każdego postępowania na rzecz tak wstępnego potwierdzenia sytuacji wykonawcy poprzez proces certyfikacji. Oczywiście certyfikacja będzie narzędziem fakultatywnym, to znaczy wykonawcy będą mogli z tego skorzystać, nie będą musieli z tego korzystać. Jeżeli nie zdecydują się na przejście procesu certyfikacji, będą mogli w dalszym ciągu uczestniczyć w postępowaniach na dotychczasowych zasadach. Jest, tak jak już wspomniałem, jest to rozwiązanie, które jest dopuszczone przez dyrektywy unijne z obszaru zamówień publicznych. Funkcjonuje ono w niektórych państwach Unii Europejskiej. Jako przykład można wskazać Słowacja, Czechy, Węgry czy też Niemcy, a więc tutaj państwa z nami sąsiadujące mają ten system wprowadzony. Oczywiście w różnych zakresach on funkcjonuje. Tak? W niektórych państwach on jest bardziej rozbudowany, w niektórych ten zakres jest węższy. Jakie korzyści identyfikujemy z certyfikacji, z prowadzenia certyfikacji? Po pierwsze, jest to przyspieszenie i uproszczenie procesu udziału w przetargach dla wykonawców MŚP. Po pierwsze, nie muszą oni gromadzić dokumentów przy każdym postępowaniu, na rzecz każdego postępowania. Nie muszą też odnosić się do przekładać ewentualnych wyjaśnień związanych z wątpliwościami, które po stronie zamawiających mogą pojawić się w związku z przedłożonymi dokumentami. Tak? Więc wykonawca przychodzi raz certyfikuje się, jakby uzyskuje takie wstępne potwierdzenie swojej sytuacji, to też stabilizuje jego sytuację na rynku. Tak? Mając certyfikat, ma jakby informacje a propos tego, czy podlega wykluczeniu, czy nie podlega i jakie jego zdolności czy zasoby zostały potwierdzone. Tak? Certyfikacja też podnosi poziom profesjonalizmu weryfikacji wykonawców. Tak? Oczywiście nie mówimy, że zamawiający nie są profesjonalni, tak? Ale zwłaszcza ci mniejsi zamawiający często potrzebują wsparcia w celu takiego dogłębnego zweryfikowania wykonawcy, więc jeżeli certyfikacja będzie dokonywana przez wyspecjalizowane podmioty, mające odpowiedni personel, zatrudniający odpowiednie osoby, ta weryfikacja będzie bardziej dogłębna. Są oczywiście korzyści dla zamawiających, to jest przyspieszenie procesu weryfikacji wykonawców. Zamawiający mogą też się opierać o ustalenia właśnie profesjonalnych podmiotów, tak? Które dokonały już takiej pogłębionej weryfikacji wykonawców, przez to jakby ograniczając czas na tą weryfikację formalną wykonawcy, zamawiający uzyskują możliwość skupienia się na tych aspektach merytorycznych weryfikowania ofert, więc w naszej ocenie jest to bardzo istotne. Oczywiście zmniejsza się też ryzyko nieprawidłowego zweryfikowania wykonawcy. Zamawiający, opierając się na ustaleniach podmiotu certyfikującego, uzyskuje taką pewność, że ten wykonawca został już wcześniej dogłębnie zweryfikowany. Czego będzie dotyczyła certyfikacja? Certyfikacja, którą proponujemy, która obecnie jest procedowana, obejmuje dość szerokim zakresem sytuację wykonawcy, bo obejmuje zarówno podstawy wykluczenia, jak i kwestie warunków pozytywnych, czyli zdolności, których posiada wykonawcy, zasobów technicznych, sprzętu, personelu. Tak? Jeżeli chodzi o podstawy wykluczenia, to certyfikacją będą objęte zarówno podstawy wykluczenia o charakterze obligatoryjnym, jak i fakultatywnym. Decyzja co do zakresu, w którym wykonawca będzie się certyfikował, zależy do niego. Tak? Może on się certyfikować wyłącznie z podstaw obligatoryjnych, może też wskazać wybrane lub wszystkie podstawy fakultatywne, które istnieją w prawie polskim. Jedynym obowiązkowym elementem w sytuacji, gdy wykonawca zechce się certyfikować z podstaw wykluczenia, zawsze elementem tej certyfikacji muszą być obligatoryjne podstawy wykluczenia, z racji tego, że one są badane w każdym postępowaniu, jak sama nazwa na to wskazuje. Istotnym elementem weryfikacji podstaw wykluczenia będzie self-cleaning. Do tej pory wykonawca, który na przykład miał jakieś kłopoty na poprzednim kontrakcie i teoretycznie podlega wykluczeniu, ale dokonał działań naprawczych, musi tego dokonywać w każdym postępowaniu, żeby wykazać swoją rzetelność. Jeżeli znajduje się w takiej sytuacji, że podlega wykluczeniu na przykład w związku z pewnymi niedociągnięciami na poprzednich kontraktach, może wystąpić o certyfikację i jednocześnie zwrócić się o przeprowadzenie self-cleaningu, tak? Czyli self-cleaning zostanie przeprowadzony przez podmiot certyfikujący i ten self-cleaning będzie wiążący już później dla kolejnych, dla zamawiających w toku konkretnych postępowań. Oznacza to, że wykonawca nie będzie musiał w każdym postępowaniu przechodzić procedury self-cleaningu, dokona jej jednokrotnie przed podmiotem certyfikującym i ten ustalenia, decyzja podmiotu certyfikującego, że można danego wykonawcę uznać za rzetelnego, będzie wiążąca później dla zamawiających, więc uważamy, że to jest bardzo istotna korzyść dla wykonawców. Kolejnym blokiem, z którego będzie można się certyfikować, będą zdolności. Będą to zdolności kwestie dotyczące doświadczenia, potencjału technicznego, posiadanych uprawnień. Tu oczywiście sytuacja jest trochę bardziej skomplikowana, zwłaszcza w kwestii doświadczenia, tak? Bo padają pytania, w jaki sposób te doświadczenie będzie ujmowane w certyfikacie, żeby później przystawało do tego, co zamawiający żądają w toku postępowań konkretnych. Więc na potrzeby certyfikacji wybrane roboty budowlane zostaną skategoryzowane i wykonawca, ubiegając się o certyfikację, będzie we wniosku o certyfikację wskazywał w zakresie swojego doświadczenia, w której kategorii jego doświadczenie się mieści. Tak? Te kategorie będą ujęte w rozporządzeniu właściwego ministra. Równocześnie, aby zapewnić jakby stosowalność tych kategorii, które będą w certyfikacie, zamawiający, opisując swoje warunki udziału w postępowaniu, również będą mieli obowiązek korzystania z tych kategorii, czyli opisując warunek w zakresie doświadczenia, będą wskazywać, której kategorii żądają. Oczywiście ta kategoria będzie musiała być dostosowana do przedmiotu zamówienia. Zamawiający będzie oczywiście miał możliwość odstąpienia od stosowania tej kategorii w sytuacji, gdy uzasadni, że kategorie, które są w rozporządzeniu ustanowione, nie odpowiadają jego przedmiotowi zamówienia. Weryfikacja wykonawcy w toku procesu certyfikacji będzie odbywała się na podstawie podmiotowych środków dowodowych, tych samych dokumentów, które są żądane przez zamawiających w toku postępowań. Jednostka certyfikująca będzie miała obowiązek, też będzie mogła korzystać z innych źródeł informacji, czyli podstawowym źródłem informacji będą podmiotowe środki dowodowe, ale w sytuacji, gdy podmiot certyfikujący posiada informacji, będzie mógł uzyskiwać informacje z innych źródeł, czyli na przykład otwartych baz danych o wykonawcach, będzie mógł wchodzić w bezpośrednie kontakty z na przykład innymi zamawiającymi w celu uzyskania informacji o danym wykonawcy, tak żeby zapewnić, aby ta weryfikacja była pogłębiona i taka rzetelna. Podmiotami certyfikującymi, tak, czyli tymi jednostkami, do których wykonawcy będą zwracać się o wydanie certyfikatu, będą jednostki akredytowane, które będą spełniały wymogi odpowiednich norm. Te jednostki będą akredytowane przez Polskie Centrum Akredytacji, które warunkiem rozpoczęcia działalności przez podmiot certyfikujący, przez jednostkę certyfikującą będzie właśnie obowiązek uzyskania akredytacji przez Polskie Centrum Akredytacji, ale Polskie Centrum Akredytacji nie będzie tylko udzielało tej wstępnej akredytacji, ale później będzie też czuwało nad prawidłowością funkcjonowania tych podmiotów certyfikujących, które zajmują się certyfikacją, tak, aby zapewnić odpowiedni standard działalności tych jednostek. Certyfikacja będzie odbywała się na wniosek, tak? Wykonawca będzie składał do podmiotu certyfikującego wniosek, który będzie wskazywał, w jakim zakresie chce się certyfikować. Tak jak powiedziałem, tutaj zostawiamy wykonawcom swobodę, oni decydują, w jakim zakresie chcą się certyfikować, czy tylko w zakresie podstaw wykluczenia, czy tylko w zakresie zdolności. W związku z tym przyjmujemy tu jakby pełną fakultatywność. To wykonawca, znając jakby swoje doświadczenie i rynek, na którym działa, zamawiających, on może jakby dostosować swój certyfikat do tych przyszłych swoich potrzeb. Po złożeniu wniosku podmiot certyfikujący będzie go, zapomniałem Państwu, podmiot certyfikujący będzie go weryfikował pod kątem formalnym. Jeżeli przejdzie pozytywną weryfikację, będzie zawierana umowa. Tak, stosunek między wykonawcą a podmiotem certyfikującym będzie miał charakter kontraktowy. Ten proces certyfikacji nie będzie miał charakteru administracyjnego. Tak? Proces certyfikacji wykonawcy będzie trwał 30 dni od zawarcia umowy, czyli od momentu, gdy wykonawca z podmiotem certyfikującym zawiera umowę, podmiot certyfikujący ma 30 dni na udzielenie certyfikacji lub odmowę lub przekazanie odmowy udzielania certyfikacji w związku z tym, że na przykład stwierdzono, że wykonawca podlega wykluczeniu. Oczywiście odmowa będzie musiała być odpowiednio uzasadniona. W przypadku odmowy wykonawca będzie mógł złożyć zastrzeżenia. To jest rozwiązane zgodnie stosowane w innych obszarach objętych normami. Zastrzeżenia będą składane do tego samego podmiotu certyfikującego. Oczywiście zastrzeżenia będą rozpatrywane przez inny zespół oceniający, tak? Nie będzie tutaj, nie wprowadzamy ścieżki odwołania sądowego. Zamykamy się, jakby tutaj ten system będzie ograniczony, zamknięty w ramach podmiotów certyfikujących. Jakie będzie znaczenie, jaki będzie charakter w ogóle certyfikatu, tak? Co certyfikat da wykonawcy? Po pierwsze, jeżeli wykonawca dysponuje certyfikatem i złoży go w toku konkretnego postępowania zamawiającemu, to zamawiający jest związany z zakresem informacji wynikających z certyfikatu. Po pierwsze, nie może żądać innych dokumentów na potwierdzenie okoliczności wskazanych w certyfikacie, tak? Więc nie może uznać, że OK, wykonawco, masz certyfikat, ale ja dla pewności poproszę Cię jeszcze o inne dokumenty. Tego typu działanie będzie niedopuszczalne. Z certyfikatu też wynika domniemanie prawne, że wykonawca w zakresie, w którym potwierdza to certyfikat, właśnie nie podlega wykluczeniu i spełnia te okoliczności w zakresie doświadczenia, zdolności, sprzętu, uprawnień, te, które zostały wskazane w certyfikacie. Oczywiście, jak każde domniemanie, też to domniemanie prawne będzie obalalne, będzie można je obalić, ale w stricte określonych sytuacjach. Po pierwsze, jest to sytuacja, w której osoba, która próbuje udowodnić, wykazać, że to domniemanie już jest danemu certyfikatowi jest już nienależne, to ona będzie musiała wykazać po pierwsze, że podmiot certyfikujący został wprowadzony w błąd na etapie certyfikacji, co miało wpływ na proces, na ostateczną decyzję dotyczącą certyfikacji, tak? Więc tutaj na przykład, że zostały zatajone przez wykonawcę jakieś istotne okoliczności lub wskazane nieprawidłowe informacje. To jest jedna z takich okoliczności, podstaw do obalenia domniemania i druga to przesłanka dotycząca tego, że po prostu po wydaniu certyfikatu wykonawca przestał spełniać już warunki niezbędne do wydania certyfikatu, czyli nastąpiła jego zmiana sytuacji i ta sytuacja już nie odpowiada tym okolicznościom, faktom, które zostały wskazane na etapie wydawania certyfikatu. To są te dwie okoliczności. Na pewno nie będzie można kwestionować oceny merytorycznej dokonanej przez podmiot certyfikujący, czyli inny wykonawca nie będzie mógł powiedzieć, że on się nie zgadza z oceną, którą dokonał podmiot certyfikujący, tak? To jakby przyjmujemy, że podmiot certyfikujący jest podmiotem profesjonalnym, jakby jego decyzje, mówiąc w pewnym sensie, są ostateczne w zakresie merytorycznej oceny, tak? Jeżeli oczywiście się wykaże, że jednostka została wprowadzona w błąd, dysponowała na przykład niepełnymi danymi, wówczas dopiero można to domniemanie będzie obalać. Oczywiście wykonawca nie będzie mógł, jeżeli nie będzie mógł posługiwać się nieaktualnym certyfikatem. W sytuacji, gdy wykonawca wie, że jego sytuacja w zakresie zdolności finansowej czy podstaw wykluczenia uległa zmianie, ma obowiązek poinformować o tym będzie miał obowiązek poinformować o tym podmiot certyfikujący i poddać się albo zawiesić certyfikat, albo poddać się procedurze aktualizacji, czyli odpowiedniej zmiany certyfikatu. Posłużenie się przez wykonawcę nieaktualnym certyfikatem, jeżeli to zostanie wykazane na etapie konkretnego postępowania, będzie mogło być traktowane, jeżeli oczywiście będzie to działanie w pełni zawinione, będzie mogło być potraktowane jako wprowadzenie zamawiającego w błąd i stanowić podstawę wykluczenia z udziału w danym postępowaniu. Certyfikat będzie też zawierał wszystkie kluczowe informacje, kluczowe i niezbędne do tego, aby inni uczestnicy rynku mogli zweryfikować, czy dane wskazane jednostce odpowiadały rzeczywistości, tak? Czyli na przykład jeżeli wykonawca certyfikuje się w zakresie doświadczenia i wskazuje określone roboty budowlane, które wykonał, żeby pokazać, że ja mam doświadczenie w zakresie określonej kategorii, o których wcześniej wspomniałem, to te roboty będą wskazane w certyfikacie, żeby inni wykonawcy, jakby trochę będzie to kontrola społeczna, tak? Czyli nie tylko podmiot certyfikujący, ale inni wykonawcy będą tak na takim dość horyzontalnym poziomie w stanie zweryfikować te informacje, które były podane. Oczywiście takie kwestie jak informacje stanowiące tajemnicę przedsiębiorstwa nie będą w certyfikacie ujawniane. Te informacje wykonawca będzie zobowiązany przekazywać zamawiającemu już na etapie konkretnego postępowania. Kończąc już powoli, tutaj też było wspomniane o elektronizacji. Certyfikację będzie stworzona baza elektroniczna certyfikatów, gdzie certyfikaty będą jawne, ogólnie dostępne, bo generalnie certyfikat będzie wydawany w postaci elektronicznej. Każdy będzie mógł się zapoznać z certyfikatem, wyszukać certyfikat po nazwie wykonawcy. W bazie też oczywiście baza będzie zawierała certyfikaty ważne, certyfikaty, których ważność została zawieszona, certyfikaty, które utraciły ważność. Będą tam też informacje o wykonawcach, którzy są w toku procesu certyfikacji, tak aby nie można było dublować procesu certyfikacji jednocześnie w dwóch różnych podmiotach certyfikujących. Tak więc to też będzie jakby aspekt elektronizacji. Planujemy, że certyfikacja wejdzie w życie w połowie przyszłego roku. Jesteśmy teraz na końcowym etapie rządowego procesu legislacyjnego. Liczymy na to, że w grudniu projekt zostanie przyjęty przez Radę Ministrów, a w styczniu przekazany do prac parlamentarnych. To z mojej strony tyle. Dziękuję Państwu bardzo.
Thank you very much. Dziękuję bardzo. Zatem any questions? Rather, this is the question to Polish participants in our conference. Czy macie Państwo jakieś pytania w związku z tym wystąpieniem do pana naczelnika? Proszę bardzo, czy ktoś ma jakieś pytanka? Proszę bardzo, czy ktoś ma jakieś pytania, wątpliwości? Ja mam tylko jedno pytanie. Na jakim etapie to teraz jest? Tak realnie.
Formalnie jesteśmy na etapie rządowego procesu, jesteśmy na Komitecie do Spraw Europejskich i Komisja Wspólna Rządu i Samorządu Terytorialnego to rozpatruje. Tak jak powiedziałem, liczymy na to, że w grudniu będzie stały Komitet Rady Ministrów i projekt zostanie przyjęty przez Radę Ministrów i skierowany do prac parlamentarnych.
Czyli to rozumiem, to raczej tygodnie niż miesiące.
No tak, jesteśmy już na zaawansowanym etapie prac, tak? Więc zmierzamy powoli do końca.
Jasne. Okej. Czy ktoś ma jakieś pytania? Dziękuję bardzo w takim razie. Bardzo serdecznie dziękuję. Jak rozumiem, artykuł na ten temat też się pojawi, mam nadzieję. I teraz oczywiście, tak jak mówiłem, informacja będzie dzisiaj lub jutro. So let's go to the second panel. And about something about regulations in Romania, beautiful country, especially Pitești. Second panel, zamówienia publiczne i roboty budowlane w Rumunii, public procurement and construction works in Romania. We have 1, 2, 3, 4, 5 papers. After that we will take the break. The first paper, Daniela Janku, PhD lecturer, Polytechnic, all ladies. We don't repeat. All ladies are from Politechnica Bucharest, National University of Science and Technology in Pitești, And the first paper, konflikt interesów w procedurach zamówień publicznych w prawie rumuńskim, conflict of interests in public procurement procedures in Romanian law. Andrea, floor is yours, 20 minutes, please. Welcome.
Thank you very much, Thomas. Daniela, it's my name. And I will start my presentation. Maybe I'll try to share.
Sorry, Daniela, sorry.
Not a problem.
Because I looked at the second.
It's Andrea, and we have two Andreas.
Yes, I know.
With
Okay.
us, so I understand, and I like very much the name Andrea, so I don't mind. I will try to share the screen. I hope that it's okay.
No.
No.
We can see.
Nu se vede.
No. Screen.
Okay. Oh, but it's your screen. Oh,
It's
okay.
my screen.
Yes, now
No.
now it's presentation. Okay, thank you.
No, it was okay.
But now not.
Not anymore.
Oh, yes.
Yes. So I won't change anything because I don't want to ruin. Okay. I will start my presentation. The conflict of interest in public procurement procedure is an integrity issue that occurs when people involved in the procurement process have personal interests that could affect objectivity and impartiality in decision making. The conflict of interest is defined in the Romanian legislation as any situation in which the staff members of the contracting authorities or of a procurement service provider acting on behalf of the contracting authority who are involved in carrying out the award procedure or who can influence its outcome have indirectly a financial, economic, or other personal interest which could be perceived as an element that compromise their impartiality or independence in the context of the award procedure. Romania has literally transposed the definition of conflict of interest as included in Article 24 of the Directive 2014-24 EU of the European Parliament and of the Council of 26 February 2014 on public procurements and repealing Directive 2004/18 EC under the Article 59 of the Law 98 from 2016 on public procurement. The legislative framework that regulates the conflict of in public procurements in Romania includes the Law number 98 from 2016 on public procurements, the Law number 99 from 2016 on sectoral purchases, Law 100 from the same year regarding works concession and service concessions, and the Law number 101 from 2016 regarding remedies and appeals in the matter of awarding public procurement contracts, sectoral contracts, and work concession and service concession contracts. Within the public procurement process, the contracting authorities has a crucial role in preventing, identifying, and sanctioning conflicts of interest to ensure the integrity and transparency of the procedures. The conflict of interest can seriously affect the results of a public procurement procedure, leading to an unjustified favoring of some economic operators or to the prejudice of the public interest. The contracting authority has the role of ensuring a fair, honest, and transparent environment in public procurement, appropriately sanctioning conflict of interest that may compromise the process. According to Romanian legislation, there are clear steps that authorities and people involved in the procurement process must follow to identify and declare conflict of interest. Law number 98 from 2016 on public procurements provides the importance of preventing conflict of interest stipulated in Article 58, the obligation of the contracting authorities to take all necessary measures to prevent, identify, and remedy situations of conflict of interest in order to avoid distortion of competition and to ensure equal treatment for all economic operators. Situation potentially generating conflict of interest are regulated by way of example in Article 16, paragraph 1 from Law number 98 from 2016 on public procurement. For example, the individual or legal entity is directly involved in the process of verification or evaluation of application tenders are not allowed to hold social parts shares, share of subscribed capital of one of the bidder candidates, third-party supporters or proposed subcontractor, or person who are part of the board of directors or the management or supervisory body of one of the bidder candidates, third-party supporters or proposed subcontractor. To be husband, wife, or close family relative up to the second degree inclusive, with persons who are part of the board of director, management, or supervisory body of one of the bidders, candidates, third-party supporters, or proposed subcontractors. To be a certain person or regarding whom there are reasonable indication or concrete information that he may have directly or indirectly a personal, financial, economic, or other interest, or is in another situation likely to affect his independence and impartiality during the evaluation process. In order to meet the element that constitutes the conflict of interest, the condition that must be met by the personal interest of the person with a decision-making function within the contracting authority is that it is able to affect the independence and the impartiality of that person. Contracting authorities must distinguish between the degree and importance of this interest, minor interest not being able to generate conflicts of interest. In the guidelines for contracting authorities regarding conflict of interest in public procurement process, based on the national legislation on public procurements and the national strategy in the field of public procurements, benchmarks are indicated in the identification of conflict of interest from the jurisprudence of the European Union Court of Justice and the Romanian courts. Regarding the prevention of conflict of interest in public procurement, it is necessary for people with decision-making function to behave ethically and correctly, fulfilling their legal obligation in the situation of the existence of a potential conflict of interest. Possible means of preventing conflict of interest are the development of an internal policy document regarding the prevention of conflict of interest, establishing ethical standards for staff with decision-making function, especially regarding conflicts of interest, completing a declaration regarding the conflict of interest for each public procurement process, and so on. The declaration regarding the conflict of interest in public procurement is completed for each separate procurement by all those involved in the respective procurement process. According to Article 62, from the Romanian law on public procurements, if the contracting authorities identifies a situation potentially generating a conflict of interest within the meaning of Article 59, it has the obligation to undertake any necessary step to establish whether the respective situation represents a conflict of interest situation and to present to the candidate offerer in that situation an exposition of the reason which, in the opinion of the contracting authority, are likely to lead to a conflict of interest. In this case, the contracting authority requests the candidate bidder to submit his point of view regarding the respective situation. In situation where a potential conflict of interest has been identified, Article 62, paragraph 3 provides, first of all, the elimination of the circumstances that generated the conflict of interest, ordering measures such as the replacement of the person responsible for evaluating the offers where their impartiality is affected where possible. The following measure may be considered depending on the existence or not of a conflict of interest declaration and the nature of the conflict of interest. Discussing the clues with the person concerned to clarify the situation, the exclusion of the person in question from the public procurement procedure, regardless of whether he is a staff member or an external expert or consultant, changing the distribution of tasks and responsibilities between staff members. Contracting authorities also have the possibility of the cancellation of the procurement procedure. Sanctioning those involved in the procurement process who are in conflict of interest is an essential component of the integrity and compliance framework in public procurement. It is that the legal and administrative response to an integrity violation and aims to deter unethical behavior, ensure procedural fairness, and protect public interest. Thank you very much for your attention.
Thank you very much, Daniela. You didn't use your time, so but it's not problem. So the second one, Andrea Dragici, PhD Associate Professor, and the paper Unikalny Europejski Dokument Zamówienia w rumuńskich przepisach, the Unique European Procurement Document in Romanian Regulation. Andrea?
Hello, Thomas.
Hello,
I'm
hello.
first Andrea, or second, whatever.
In program, you're first.
I'm first, yes.
Yeah.
But because my English is not very good, I asked to my colleague Daniela Iancu to present my paper for you.
Wow,
It's okay?
Okay.
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 Thank you.
But have you a presentation or something like that? Presentation?
Yes, Dana?
Yes.
Yes.
Aha, okay.
Yes.
So could you share with us?
Yes, just a moment.
Excuse me, Thomas.
Yeah.
My colleague talked before about the conflict of interest. And you saw the definition we have in the law, in our special law. And is there, of course, by starting from the spirit of European level directives and so on, we have there the person who has a financial interest or other interest. Do you have this other interest for this other interest, a definition somewhere, or is it something clear? Because we have problems in the jurisprudence with this notion, other interest. The person who is relied with the commission of who evaluates the candidates has a financial interest. That's clear. And then the law says or other interests. And it doesn't define them. It doesn't says moral interest or something else.
Excuse me, but you are talking about Romanian law.
No, I'm asking you if you have the same idea in the Polish law, if you know, of course, because in our jurisprudence is not clear what this other interest can be.
I don't know really because it's my not area on procurement, but some topics of that. But I don't know but I don't remember really because I don't know this act in details. So I can, if you will write to me, I will check.
Yeah.
Okay.
I'll try to write on your email or something.
But
yeah,
I don't remember really now. So
yes,
because
of course, I'm just asking because I'm interested.
Yes.
What is the solution of this thing in your legislation, if it is one?
I don't know. Write to me an email and I will check it. But I don't remember this kind of regulation.
Okay, thank you very much.
Thanks. Okay.
No, it's okay.
We can see the presentation.
Oh, great.
So the unique European procurement document in Romanian regulation, please. Floor is yours.
Thank you very much. The European Single Procurement Document was established at the level of the European Union by Commission implementing Regulation 2016-7 of January 5, 2016, establishing the standard from the Single European Procurement Document. At the national level, the legislator has integrated provisions related to ESPD, both in the contents of law number 98 from 2016 regarding public procurement, as well as within the scope of law number 99 from 2016 on sectoral procurement, allocating a special section called the Single European Procurement Document, e-Service, in the chapter Organization and Conduct of the Award Procedure in both legislative acts. The objectives were the need to simplify and reduce the administrative burden for contracting authorities, contracting entities, and economic operators, especially in the case of SMIs, by replacing the various national self-responsibility declaration with a standard form established at European level. Avoiding contradictory indication in the various procurement documents, requiring that the information presented in the ESPD be clearly specified in advance by the contracting authorities and contracting entities in the invitation to the competitive bidding procedure or by references to other parts of the procurement documents on which economic operators have to carefully examine when submitting offers. The mandatory nature of ESPD. ESPD is a mandatory both for the contracting authorities, contracting entities, and for the economic operator participating in the award procedure. Starting from 8th of April 2019, the European Single Procurement Documents is integrated into the electronic public procurement system and is generated automatically. Direct purchase and negotiation without the prior publication of a tender notice are an exception to the completion of the ESPD, as direct purchase is not considered a genuine award procedure and negotiation without the prior publication of a tender notice takes place offline, outside the ECIP platform. Reasons for exclusion, qualification criteria, and selection from the perspective of ESPD. Directive 2040-42 EU of the European Parliament and of the Council on Public Procurement and repealing Directive 2004-18 regulates in Article 55 two categories of reasoning for exclusion: mandatory reason and optional reason. The mandatory reason for excluding bidders from the award procedure refer to specific crimes listed exclusively, as well as the non-payment of due tax obligation, while the optional reason for exclusion refer, as the case may be, to the violation of applicable environmental, social, and labor obligation, the state of insolvency of the economic operator, the commission of a serious professional misconduct that calls into question the integrity, The conclusion of agreements aim at distorting competition, conflict of interest, distorting of competition through the participation of the economic operator in the preparation of the award procedure. Criteria to be met by the contracting authority, law number 98 from 2016, and the government decision number 395 from 2016 distinguish three types of criteria that can be established by the contracting authority through the award documentation, respectively: qualification criteria, selection criteria, and award criteria. The qualification criteria regarding the capacity, the capacity are aimed at demonstrating the technical, financial, and organizational potential of each economic operator participating in the procedure, a potential that must reflect its concrete possibility to fulfill the contract, framework, agreement, and to solve any difficulties related to its fulfillment in case his offer will be declared the winner, while the selection criteria aim to select the candidates with the greatest economic and financial, technical, and/or professional capacity among the economic operators who submitted a request to participate in the case of application award procedure that take place in several stages.
Daniela, sorry,
Yes.
but something with presentation. Is it? But it's a problem, but we can see it.
Yes, because this part is not on the slides.
Okay.
Okay. So we must distinguish between the qualification and the selection of candidates, the latter being a distinct process which takes place after the qualification process and which aims only to limit the number of qualified candidates who will submit the offer in the second stage of the restricted tender, or, as the case may be, who will participate in the dialogue negotiation. According to the law, the selection is made by giving each candidate a score that must reflect his ability to fulfill the contract to be awarded. The steps of awarding a public procurement contract take shape in the stage of organizing the procedure, in which the contracting authority verifies whether there are any reason for exclusion, meaning that the economic operator who are not in situation of exclusion will be verified by means of the qualification criteria. Subsequently, candidates who meet the qualification requirements are to be selected based on the selection criteria. After the completion of the selection process, the award criteria intervene by contracting authority evaluating the most advantageous offer from an economic point of view based on the award criterion and the evaluation factors provided for in the procurement documents, respectively: the lowest price, the lowest cost, the best quality price ratio, or the best quality cost ratio. The qualification or selection criteria have a key role in the awarding of the public procurement contract, and it is required that they allow the tenderer to outline an extremely clear vision of what he is going to undertake in terms of technical, professional, and financial capacities, not being indicated that the contracting authorities use the procedure of request for clarification to make genuine changes to the requirements established by the award documentation. In this sense, the jurisprudence of the National Council for the Resolution of Appeals offers us multiple examples. In a case with the award of a contract for the modernization of a thermal power plant, the appellant accused the contracting authority of abusing its right by requesting technical documents that were not included in the award documentation. Resolving the case, the Council retained the appellant's compliance with the contracting entity's request to transmit the list of equipment for the automation and the electrical installation containing specification and technical data sheets by response number 30,241 from 18 of March 2019. However, the appellant did not specify the type and model of each piece of equipment, but the Council noted that the contracting entity did not establish such a requirement through the award documentation, a situation in which it cannot impute to the appellant its non-fulfillment. Clarification request as follows from the content of Article 114, paragraph 1 of the government decision number 394 from 2016 concerns formal aspects or confirmation of what was requested through the award documentation and not the fulfillment of requirements that exceeded the award documentation. Practically, a disguised modification of the qualification criteria is avoided by using requests for clarification, which would contravene the principle of transparency and the principle of equal treatment outlined by the legal provision on public procurement. Also, in this area, regarding the addition to the award criteria or their modification after the publication of the award documentation, we also find debates in the judgment in the case of Lianakis, in which exactly such an issue was resolved. In this case, the contracting authority specified in the notice of participation only 3 award criteria, namely similar experience by carrying out similar activities in the last 3 years, the livestock and the equipment provided by the bidders, and the ability to carry out the study within the stipulated period without providing for factors of evaluation or the relative weight of each of them. During the procedure, however, the contracting authority established weighting coefficients and sub-criteria for each of the award criteria provided in the award documentation, which is why the European Union Court of Justice sanctioned this conduct, arguing that potential bidders must be able to know at the moment of preparing own offers the existence and importance of this element. As a consequence, a contracting authority could not apply weighting rules or sub-criteria of the award criteria that it did not previously inform the bidders. Moreover, bidders must be treated equally throughout the procedure, which implies the obligation that those criteria and conditions governing each contract be subject to appropriate publicity by the contracting authorities. The examples above demonstrate the need to establish and diligently apply the criteria for qualification, selection, and award in the mirror with the respect and assumption exactly of the principle established by Article 2 of Law 98 from 2016 on public procurement, namely non-discrimination, equal treatment, mutual recognition, transparency, proportionality, and assumption of responsibility. Thank you very much for your attention.
Thank you, Dana, for help.
Thank you very much, Daniela and Andrea.
Thank you.
Cooperative paper. Thanks a lot. So the third one, Amelia. I don't know how to pronounce your surname. Sorry. Gienalescu?
Gheoculescu.
Excuse me?
Gheoculescu.
Oh, Gheoculescu. Sorry, Amelia, but it's difficult for me.
It's difficult also for some Romanians, so it's not a problem.
It's like something like Polish Brzęczyszczykiewicz for foreigners, so it's something like that. Andrea, coś tam, PhD lecturer from the same university, and her paper reżim prawny stowarzyszeń zawartych w celu ubiegania się o zamówienia publiczne w prawie rumuńskim. The legal regime of associations concluded to bid for a public procurement contract in Romanian law. Oh, we can see presentation. Really? So, Amelia, please.
Can see it?
Yes, we can see it.
Okay.
Floor is yours, please, Amelia.
Thank you. Nice to see you again. I prepared for today the legal regime of association, concluded to bid for a public procurement contract in Romanian law. Harmonized rules at European level regarding public procurement associations are an integral part of the European Union's efforts to create a competitive, transparent, and non-discriminatory environment in this field. These rules are laid down in the European Union Public Procurement Directives and are transposed into the national legislation of the member states to ensure a uniform framework of application. Here are the main legal aspects that regulate this association in Romanian law. Law number 98 from 2016 on public procurement and associated methodological norms. Law number 99 from 2016 on sectoral procurement and law number 100 from 2016 on works and services concession. Also, the civil code provides the general rules for association and operation of partnership contracts. Freedom of association is a fundamental principle in the field of public procurement, which allows economic operators to collaborate to participate in tender procedure. In the context of public procurement in Romania, it is established by law number 98 from 2016 on public procurement, which gives economic operators the right to participate either individually or jointly by forming an association. The characteristic of freedom of association are joint participation. Economic operators, this is actually what is interesting for us. Economic operators may form association to combine their resources, expertise, and technical and financial capacity necessary to fulfill the tender requirements. These associations allows them to compete for contracts of a complexity or value that they could not handle individually. The association contract, regulated by civil code, is an essential document within an association of economic operators who wish to participate in a public procurement procedure. This contract establishes the relations between the parties and the way of collaboration through the duration of the tender and possibly during the implementation period of the one contract. As a rule, associations appoint a leader who acts as a representative in relation with the contract authority. This leader centralizes and coordinates the joint activity of the association members, ensuring efficient and coherent communication. Freedom of association gives economic operators the opportunity to complement each other, bringing together various specialization and resources. This enables the association to better respond to the complex requirements of public procurement. Joint liability. is an essential principle applicable to association formed to participate in public procurement procedure. This concept implies that all members of an association are jointly and severally responsible for fulfilling their obligations to the contracting authority. Joint liability is a legal condition that protects the interests of the contracting authority and ensures that associations formed to participate in public tenders are able to fulfill contractual obligations properly. It is an effective mechanism that guarantees the continuity and quality of the implementation of public projects, even in the event of unexpected difficulties. Technical and financial qualification is an essential requirement in the selection process of economic operators who wish to participate in public procurement procedures. The purpose of this requirement is to ensure that bidders have the ability to perform the contract to the standard imposed by the contracting authority. In the case of associations of economic operators, each member can contribute its resource and expertise to meet the technical and financial qualification criteria. Thus, the association as a collective entity must meet the qualification requirements imposed by the contracting authority. Each member of association may contribute some of the necessary turnover, experience, or technical resources to meet the requirements. Even the association meets the requirements as a collective entity. It can exist the possibility that the contracting authority may require that the leader of the association or a specific member meet certain specific requirements, such as a relevant similar experience. Warranties and documentation are fundamental tools that ensure the integrity and transparency of the public procurement procedures. The guarantees protect the contracting authority against the risk of non-performance, while the documentation ensures that the economic operators meet all the legal and technical criteria necessary to participate in the tender. A careful preparation of the documentation and compliance with the requirements imposed by a contracting authority contributes to the success of participation in the public procurement procedure. During the tender participation phase, the association is not obliged to adopt a specific legal form. However, if their bid is declared the winner, the contracting authority may request that the association become a separate legal entity for the signing and implementation of the contract. The transformation of the association into a specific legal form refers to the process by which a temporary association of economic operators initially created to participate in a public tender or to carry out a specific project is transformed into a distinct legal entity in a different kind of company. The reason for transforming the association into a specific legal form can be for more effective project management, access to funding and resources, consolidation of responsibilities, and expansion of activities. Compliance with public procurement principle is essential to ensure transparency, fairness, efficiency in the use of public funds, equal treatment, proportionality. These principles are established to ensure fair competition between economic operators and to protect the public interest. I have some examples of relevant jurisprudence in the matter of association established for public procurement. with an emphasis on the decision of the National Council of the Resolution of Contestation and the Romanian cards. These examples highlight various aspects related to the formation, evaluation, and responsibilities of public procurement association. One of them is the cumulative qualification capacity of association. This National Council of Resolution of Contestation decided that an association accepted the association appeal and determined that it is legal for members to cumulatively meet the qualification requirements unless the work documentation states otherwise. The decision underlines the principle that association can contribute in a complementary way to meet the minimum requirement for experience and resources. Other jurisprudence on the principle of non-discrimination, decision 276 from 2020. An association challenged the tender documentation that required all members to have specified equipment necessary for the execution of the contract. The council found that this requirement was discriminatory as it limited the possibility of the partners in the association to distribute their tasks according to each one's specializations. The council decided to modify the documentation to allow cumulative fulfillment of the technical equipment requirement. Interpretation of experience requirements in the case of association. Here is a decision of the High Court of Cassation and Justice, 140 from 2019. The court analyzed the experience requirement for a public works contract in which an association participated. The contracting authority had requested similar experience for each member of the association. The court established that the authority cannot require each member to have individual experience if this requirement is not explicitly provided for and justified, considering that the association experience can be accumulated and evaluated as such. Concluding, an association to participate in a tender in public procurement contract can offer multiple advantages for the economic operators involved. This strategy allows companies to combine their resources and capabilities, increasing their chances of success in obtaining the contract. Here are the main benefits of such association: consolidation of resources and expertise, fulfillment of qualification and selection requirements, reduction of risks and distribution of responsibilities, increased flexibility and adaptability, increasing competitiveness, and access to larger and more complex projects. Entering in an association to bid in a public procurement contract gives economic operators the opportunity to collaborate and leverage their resources and expertise. This type of association is subject to a strict legal regime aimed at protecting the public interest and ensuring a proper execution of the contract. Thank you very much for your attention.
Thank you very much, Amelia, for very interesting paper. I will ask you something, but after all the papers, and the fourth one is the paper Andrea Tabacu, PhD, associate professor from the same university, of course. her paper procedury i odwołania dotyczące zamówień publicznych w prawie rumuńskim, procedures and appeals regarding the public procurement contracts in Romanian law. So, Andrea, floor is yours, please.
Thank you very much. But Thomas, I was already told you yesterday. Here is I'm reading. We need permission to share your screen.
Yes, but
So-
but can you share your presentation?
I try to do that, but I'm not so sure that I'm able. Do you see my screen now?
No.
No.
At the
Because-
right at the
Yes,
right
I know.
top.
I saw the share button, and I did everything that says here. But
Okay.
say security and privacy settings. I'm afraid it's something with my computer. I don't know. You need permission to
so-
share your screen.
Yeah, so you have something.
They sent
with
me
your-
to the security and privacy screen recording
Yes,
and so
yes,
on.
I know. So your computer is very hard secured, I think.
Yeah, it must be. It must be.
So we can share your presentation, and you can say to show next slide, for example. Okay?
Yes, if I'm able to follow the slides, because usually I don't do
Yes.
it.
So
I'm just talking, but if you can present, first of all, the title,
Yes,
and then
yes,
I will
yes,
try
yes.
to tell you how to change.
Pani Katarzyno, pani słyszy? Proszę udostępnić. So I am just talking to our IT.
Yeah, I understand.
Pani Kasiu, proszę udostępnić prezentację pani. Tak, pani Tabaku.
Yes, this is it.
Yes. So Andrea, could you tell us to show next slide and our.
Yes, I will try. I told you I will try, because usually I don't follow the slides, but I will try. Okay.
Sorry.
I'm just talking. I'm used to just to talk.
Okay.
About electronicization, as you named your conference, which is very interesting, and I tried to follow all the papers starting from yesterday. I saw that many of us are interested in the public procurement administrative proceedings. I mean, electronicization during these administrative proceedings. I am interested in the proceedings before the judge or a forum with jurisdictional power, because also electronification is needed here, and the proceedings before the judge, I name it generally the judge, because it's not always a judge. I think this electronification is needed also before the courts, but we don't have much in this field now. In order to choose these ideas, when we find electronification before the courts or before the jurisdictional forums that are provided by the law, I'm interested first in a short presentation of our law, because we had this kind of regulation regarding the public procurement even before the accession of the EU, I mean before 2007. But our legislator was very well inspired by the European directives. As you see on this first slide, our first regulation, I mean the government emergency 34 from 2006, was inspired by the directives 18, 17, and so on, and also by the directive 665 from 1989, which is the one I'm interested in, because it talks about the coordination of laws, regulation, and administrative provisions relating the application of appeal procedure in the matter of awarding, supplying, and work contracts. So our legislator before the accession of Romania in EU was inspired by these directives, and he tried to accomplish all the aims of that directive before the accession. The problem was, you can change the slide, please, if it's possible. The problem was that, okay, this law included both substantive and procedural norms. That means in the same law you found everything about the awarding proceeding in an administrative phase and stage, and also the jurisdictional proceeding before the National Council, because we have one, and also before the judge after the council, or in direct application if that was provided. So this regulation was criticized for lacking of efficiency. So our legislator tried to do something or to move forward, and he did it after the directives from 2014. I mean, the directive 24, 23, 25, and also keeping in mind the directive 665, which he used to create a new legislation, and this new legislation was the one that my colleagues presented before. I mean the law 98/4 regarding the public procurement contracts. That's the general law. The law 99 from 2016 regarding sectorial acquisition. The law 100 with work concession and service concession. Can you change the slide, please? I'm talking about the new legislation. And the law 100, change the slide, please. Okay. And the law 100 from 2016 on remedies of appeal and in matter of awarding public procurement contract, and all other types of awarding contract, because this law is the procedural law for all of them. Yes, you can change now, please. Thank you. In order to speak about electronification, I told you I'll try to present how the legislator, the Romanian legislator, found this useful in the regulation, because as it was inspired by the European regulations, directives, of course, and other compelling documents, the Romanian legislator tried to improve the X regulation from 2006 and provided efficient and fast means of appeal in case of violation of European legislation in the domestic regulation, as was presented above. The Romanian legislator, yes, you can change, tried to give two paths for the person interested in going before a judge. So we have, on one hand, the possibility to file an appeal before a national council. A national council, you have it on the left side of the slide, is the Council for Settlements of Appeals. This is the translation, but you will find it in the paper and all over for the slides as SNCS. That means the National Council, or the council I will refer at. And here we have specialists. We don't have judges, we have specialists, but independent specialists who can solve the litigation with jurisdictional power about the awarding proceeding. That means we have the possibility to go to the council only during the award proceedings. If the proceeding is finished, is final, because we concluded the contract, this council cannot be filed. On the other hand, we have the possibility to go to the judge. And here we have two other possibilities. It's a large classification, but if we went before the council, we go to the judge against the decision of the council, because in Romania, as in all democratic countries of Europe, we are talking about access to justice. Our constitution and the Civil Procedural Code also provide this access to justice, which is so necessary in all democratic countries, as I said. So against this decision of the council, which is a jurisdictional forum, we have the access to a judge. And then we have the direct actions before the courts or before the judge, if we are granting for compensation or reparation of damages, or if we ask the cancellation or nullity of the contracts, of the administrative contracts, or some others requests, or hello, am I here?
Yes,
yes, you're here.
Okay, here it was My originator stopped for a second. Excuse me. So we have two possibilities: to go to the council or to go to the judge. If we go before the council, the procedure before the council is a very quick one. I'm talking about celerity, the principle of celerity. If it's understood or not, I think it's a juridical term. We cannot translate it elsewhere or how in other terms. The celerity or the quick proceedings is provided in the law before the council, and this means that the legislator provided short deadlines, very short deadlines, I mean 10 days, 7 days, in order to go to the council, to notify the council against a document which was provided or which was drafted in the award proceeding, in the administrative award proceeding. Also, the council, yeah, you can change, please, can you change the slide? The council is compelled, okay, to use the general or usual procedure which comes from the Civil Procedural Code, but it has also something specific because the special law tries to quick the proceedings. So the law 101 from 2016 I'm talking about force the participants, I mean the person who goes to the judge or who goes to the council, I mean the applicant, to file in this, to present in his file the electronic mail address, the number of telephone or fax number, because we need to communicate fast. And this is not provided in the general law, in the Civil Procedural Code. It's just something let to the wish or the possibility of the applicant. Here, he is forced to present it because the communication will be faster. What is specific before the council, here I said we are not talking about judges, even if we are talking about independent persons, independent specialists, because we do have here jurists, and in each panel of 3 members before the council, we do have to have only one of them, at least one of them, with a law school, who graduated law school, and with minimum 9 years of experience in the legal field. And the other one are technicians, specialists in other fields, because here we are talking about the administrative awarding proceedings. That means these people must understand very well the technical face of the idea of this proceeding. They must understand everything technically, and they have to be specialists in different field. By example, when I'm talking about energy and water or something else, in this panel of 3 members, we have to have one specialist in that field. Before the council, we also have the principles, general principles coming from the Civil Procedural Code, but which are also seen in the special law. I'm talking about adversarial proceeding and right to defense, impartiality, independence of the members, of the administrative jurisdictional activity of these members, specialists I'm talking about, and also the principle of good faith. Everybody must present their file and their application in good faith, not coming there just to stop the proceeding or just to abuse of this right to seize the council or to notify the council against a document or something which happened in the proceedings before the administrative, before the authority which develops that proceedings. We can change the slide, please. Okay, in this proceeding before the council, we also have the possibility to go to see the documents of the other participant in the proceedings, because here we have a contrary or contradictoriality proceeding. That means everybody can see the documents of other participants in the same awarding proceedings. And for the access to the documents, we have some provisions in the special law, and I'm interested here in the one which allows to the economic agent to say or to invoke that the data, his data, are confidential. I'm talking about technical or commercial secrets or something which whose disclosure will affect him. And if he says so, or if he declares that, the other one cannot access them. Only the access can be only limited on the this information, kind of informations, and this is something which will limit his possibility to draw the application or to say the criticism or to present the problems of that awarding proceeding, because he will not know the content of the documents of the other participant. Also here, the celerity I'm talking about is granted, is provided in the special law 2. We have the provision that the council is forced to finish the main problem is that the law forced him to finish the proceedings on the merits. That means he has to take the evidence or to do everything is necessary in order to have a decision on the merits, which is very difficult. The council also have the possibility to order the suspension of the award proceeding, or to suspend or to stop the appeal resolution proceeding before the council, because here we go to the general rules where the civil procedural code provides that if another proceeding is pending and this proceeding is a criminal one, by example, we should wait for the solution in that proceeding in order to have a good or correct solution in before the council. Change the slide, please, with the solution. Here I'm presenting the possible solution that the council can deliver, and for me it's important. I will not present all of them because it's the content of the law and you can access it in the paper I will send. But what is very interesting is the second line. If you see the council, the national council can compel the authority to issue an act or to adopt necessary measures to restore legality, because this is the reason we are going before the council. And here the law says that the council is compelled to present a clear and precise indication of the operation to be carried out to the contracting authority or to the participants in the proceeding. If he doesn't do that, if he doesn't say what is the necessary measure or what is the act or the issue to adopt, there are consequences for the members of the panel, and I mean here disciplinary liability if this is proved, and is very easy to be proved because it's the content of the decision of the council. It is not enough if the council says we admit the application, we force the authority to do something necessary to solve the problem. This is not enough. It has to be clear and to present precise indication in the decision what the contracting authority must do. The other solutions are not interested for the celerity and for the, we can change the slide, and for the specific of the procedure before the council. I was talking about also, on the other hand, about the access to the judge. And this access to the judge, I already told you, it's possible in two ways. If the council was notified, if the interested party went before the council and this one solved on the merits or not the litigation, and on the other side, we have the judicial path, which is followed directly. If a party is interested not to go to the council because it's not forced to do it, because we have the access to justice, that means the interested party is the only one who chooses the path to use. So if we go directly to the court, we have the possibility to ask on one hand, to censor some documents or acts which are provided by the authority or the counting authority in pending in the administrative procedure pending of awarding the contract, and the other possibility is to go directly to the judge in order to ask for abolition, execution, termination of the procurement contracts, meaning that in this stage we are after the concluding of the contract. That means the awarding proceeding is finished. Please change the slide. So with this classification, we start with the proceeding before the council, if it was followed, this proceeding before the council, and we have a decision of this one, of the council, of the national council. If we have a decision of the national council and we go to the court against it because we have to respect the general idea of access to justice, we have for the court deadlines, and also for the applicant who must go there very quickly. I mean, 10 days, not more, even if the value of the contract is under or up to the thresholds that value of the contract which need a publication in the official journal of the European Union. We have this kind of litigation at the level of the Court of Appeal because we need experienced judges, and we also have to have a specialized court, meaning we have to go before the administrative court. It's not just the Court of Appeal, it's not a civil panel, it's an administrative panel of specialists in this field. And also we have specific rules for the applicant and for the respondent. And here the celerity idea I'm trying to develop all over the content of my work has a lot of obligation by the law. Obligation for the parties, I mean the applicant and the respondent, which are not obligation of the court. If we are talking about civil procedural code, we have the obligation of the court, or any court, to communicate or to serve the documents they receive in the proceedings. Here, the law, the special law, force the applicant to communicate in private, if you want, the complaint to the respondent. And the respondent, which can be the contracting authority or other one who participated in that proceeding, has to answer and also to communicate this answer to the applicant. That means we have this private communication, which must be done in delays, very short delays, 3 or 5 days. And also we have a delay, I said, for the court. If we had the file, the application came to the court, we have 45 days in order to finish the proceeding, the jurisdictional proceeding. 45 days is not a delay, an usual delay for proceedings, because I don't know how much or how long are the proceedings in Poland, but here in Romania, usually proceeding civil ones are maybe more than 3 years. Here we have 45 days to finish and to deliver a final decision, because if we are going before the court against a decision of the council, we will have a final decision before the court. These 45 days are impossible to reach. Also, in this term, on this delay of 45 days, we have provisions in the special law that the court cannot expect a delay, the first delay, for 20 days. The court can, by example, postpone the decision by 5 days. The court must draw up the decision, I mean here, with the motivation of the decision in 7 days. And all of this must be done in the 45 days delay I'm talking about. Please change the slide, please. Okay. What is the procedure before the court if I go against the council, against the decision of the council? First of all, we can say we have the general rules here, which are repeated in the special rules, because we don't have much differences by the civil procedural code. By example, we have the complaint which must be formulated in writing, but the difference is that this communication or the service of documents can be made by the national electronic system. That means I formulate the complaint in writing, I put it at the level of the email, by example, of the court, I send it by email to the court, and the court can send it to the council, and the council will present it, will publish it in the national electronic system, that every other participants in that proceeding must see the content of the complaint. It's a full adversarial proceeding. We have also the right to defense here, which is something, a special thing is or can be understood that the law says especially that if you go before the council, you cannot go before the court with other reasons that you had before the council. So that means the reasons are the same. You cannot develop your application or your request before the court against the decision of the council, coming with some other reason, by example, because before the council you had the possibility or the opportunity to see the informations and the data from the documentation of the other applicant or the other participant in the proceeding, usually the winner. Also we have here a provision about the communication private between the parties. The law says that the parties are the one who will serve the documents. They will send the documents between them, and they will have to prove before the judge that they did it, because if they don't prove, by example, the applicant has to prove that he sent the application to the defender. If he doesn't make this proof at the first term when the judge is present, the penalty of this attitude will be the rejection of the complaint. And this is very important for the applicant, because if we do have this hypothesis in the practice, we also have a lot of jurisprudence here. We can have a lot of problems because if we don't find the specific correct address of email of the other party, and we use another one, which is an official one, we cannot have a correct communication or a correct service of documents. I have here a decision, by example, which was drafted here in the Court of Appeal of Pitești, when the applicant came before the judge and he said, I send, and I prove that I send the application, the request, to the authority, contracting authority, and this is the email address, official one, I found on the net. The authority came before the judge and said, no, I never received something from this applicant. I don't know about these proceedings. That's the real email address of our service, but is not used in awarding proceedings. We don't use it. We have a special one here, and this is not the case. So the court rejected the complaint because the applicant couldn't prove that he sent, in the delay of 10 days I'm talking about, the complaint to the other one, to the defendant, to the authority, which was the contracting authority in the proceeding, in the administrative proceeding. So he will be very interested to find all the proofs necessary to show to the judge at the first term, when the judge will be present, to that he sent and that he correctly communicated that document to the authority. Change the slide, please. What are the solutions that the court can pronounce? There is not much to say here, because if you compare it with the possibility of the council, we have this almost the same thing. Also, the judge must present, if he adapts a solution of admission of that request or complaint, he will have to say very clear to the contracting authority what it has to do in order to solve the problem, what are the measures to be taken in the future in that pending proceedings. But what it is interesting here, if it's a fact, it's a problem, I find, that the law is the one who doesn't allow the celerity principle to be accomplished here, because the law says if the court finds that the solution will be an admitting one because the council solved or delivered the decision admitting a procedural exception, that means the council didn't file the decision on the merits, but on an exception, I don't know, something regarding the delays or something regarding the quality of the applicant, or he is not an interested person or something like that, not on the merits, as I said, the court can admit this complaint and it has to annul the decision and to remand the case for the trial on the merits. And the law says that if this happens, we need two decisions. Two decisions meaning that first, the court will decide the annul of the respective decision of the council, and that must be motivated. That can be postponed 5 days. I remind you that everything must happen in 45 days. And then another decision for the proceeding, the parties must be summoned, the parties must be called before the judge. Also, the decision must be communicated or must be served to the parties in order to be able to exert the right to defense. And we have a second delay or second term before the judge when we are talking about the merits. This is not possible to accomplish in this way. Is not possible to accomplish the principle of celerity, which is especially provided in this law. We go then, next slide, please. I think this slide is just the solution I already presented, okay? The problem with the quick resolution of the case, we don't have the possibility to have a quick resolution of the case because the law provides two steps of the proceedings, two decisions, two terms before the judge, and two proceedings, general proceedings for a final one, to have a final one on the merits, because the court has to have to deliver a decision on the merits at the end. So the delay of 45 days is not respected. Even if we are talking about serving the documents by email or some national electronic system, it's impossible to be reached. So next, the judicial path. Next slide, please. If the judicial path is followed directly, why do I go directly to the court? Because I didn't choose to go to the council before the council. I don't seize the council, even if it has a lot of specialists. And I can say here, compared to the judges, which are not technicians, they are just judges and they have to know everything, of course, but they are not specialized in that field. I can choose to go before the judge. I go to the judge to contest and to challenge the same documents I can contest before, or I can challenge before the council. That means it's not a parallel proceeding. It's a different proceeding I choose from the start. I'm in a pending administrative award proceeding and I go directly to the judge because I don't trust in the council, or I don't want to go there because after the council decision I have to go to the judge and so on. These reasons are not provided in the law and not interesting for the legislator and also for nobody. So it's the choice of the applicant. If the applicant chooses to go before the judge, We also have here the same provisions regarding the quick proceeding. We also have 45 days for the judges to solve, to deliver the final decision. And also short delays between the terms that the judge uses in order to solve the case, to take the evidence, or all the steps you have to pass for the final decision. And these delays you have on the slide, you see they are very short, 5 days, 3 days, 7 days. The problem which comes here against the celerity principle is the possibility that the law provides in order to attack or to challenge the decision, the first instance decision. And we have here an appeal within 10 days of the communication of the decision, which will be delivered at the Court of Appeal, I mean the next court, the next level of courts. And this proceeding will last also 45 days. That means we have 2 levels we have the possibility to go to. Change, please, the slide. The law, the special law, talks about the competent court, which is the Court of Appeal here for the appeal, and also the same principle, general principles. We have the contradictional principle, the right to defense, and so on. All the general principle we have in a civil procedure, generally civil procedure. For the communication of the appeal, we have the special provision that this will happen to the national electronic system. That means here we don't have the counsel implicated. It's not he didn't deliver the decision because it was not notified. We go just before the court directly to the judge. And in this, even if we have this hypothesis, the parties will file the appeal, and the appeal will be communicated, will be sent, will be served through the ESPP. That means the general system, electronic system, which will allow all the participants in that proceedings to know the content of this appeal. Unlike the complaint, because the complaint usually is not taxed, you don't have a tax here. Here, the appeal submitted to the competent court is taxed with 2% of the estimated value of the contract. That means we can reach even 20 million euros. I'm trying to change that sum there you have on the slides on the last part, at the final part, because that sum means almost 20 million euros, which can be asked to the interested party in order to file an appeal. And the third category of litigations, we can change the slide, please. We have a special proceeding in order to grant compensation for damages caused during the award proceeding, which I don't know much, or to demand execution, cancellation, nullity, resolution, termination of, or that's also I don't see much, unilateral denunciation of the contract. Also, the competent court is the administrative court. We are talking here about tribunals. That means the second level of courts in our Romanian system, and with the possibility to go to file an appeal to the Court of Appeal. That means the next level under the High Court of Cassation and Justice. As you see on the slides, we also have here a delay for the judge to finish the proceeding. We have 45 days, but if we are talking about the delay necessary to file the application and to send it to the court, that means if we are talking about the delay, it's at the appreciation of the applicant, because he is the one who decides if he goes or not. before the judge. We have different delays. By example, we have 1 year for the birth of the right of actions regarding the granting of a compensation. We have 3 years if we are talking about the actions regarding the execution, cancellation, and nullity, and of course 30 days if we are talking about resolution, termination, or unilateral denunciation of the procurement contract. All of this, of course, happens if the contract was concluded. We are in the next step. But what I want to say here is that even if the applicant has long delays, for example, 3 years or 1 year, it's enough for him to think if he will go to the judge. After that, after he goes to the judge, he files an application. The judge has only 45 days to deliver the decision, which is never respected in the jurisprudence. Also, in these 45 days, as you already seen in all other proceedings, the court can postpone the ruling 5 days and it must draw up the decision in 7 days. So very, very short terms for the judge and long for the applicant, which is not exactly on the idea of celerity of the proceedings. What problem, you can change the slide, please. What problem can we find here? The law, our special law 101, changed a lot. As I was a judge, maybe every year 3 or 4 times, we started a proceeding and we finished it under 2 or 3 laws. And this proceeding, as you remember, happens by 45 days, not more. We tried to respect this delay and we usually did it, but not always. So this change of the law gave what we have today, but I'm talking about the present form of the law, which is not a happy form because the judges don't know what to do. By example, we have provisions for the possibility to go to file an appeal against the decision of the administrative litigation court on one hand, compensation actions, execution, cancellation, nullity actions, and on the other hand, regarding the ascertaining document, which is drafted by the authority contracting authority, which finished a contract and ascertain that the applicant did everything okay or did something wrong. This asserting certificate or document can be challenged before the court. So we have 2 parallel proceedings. In the first case, if we are talking about compensation, execution, cancellation, nullity, and so on, we have the possibility to draft an appeal against the decision within 10 days, and that goes also to the court, to administrative court, to special judges in this field. And in the second case, we have also an appeal within 10 days, but it's not an appeal as we are talking about, is the second appeal. We are talking here in Romanian law about recourse, which is limited to some reasons, and the grounding reasons must be only grounded of illegality, which doesn't allow to the judge to go to the merits. It just doesn't allow to the judge in this control to find if the applicant or the other one, the defendant, were right. And this difference between the 2 proceedings is not justified. We have the same judges who participate in different panels and in different proceedings in the same court with the same idea of awarding proceedings, which is not justified. And another problem, a very big problem of the jurisprudence in the present nowadays, is that the law in the second type of cases doesn't specify if the first case can be subject of a second appeal or not. It doesn't says, and the judges, some of them appreciate that the decision that means the appeal decision of the appeal, can be the object of the second appeal, I mean a recourse before the High Court of Cassation, and another part says, no, the idea of this legislator was the celerity principle, and we have to hurry, we have to have quick proceedings, we are not allowing another recourse, the second recourse. So some of them in one way, some of them in other way. We will not have uniformity. European legislator doesn't require uniformity between the states. If we are talking about the legislation of one state, I think we have to have this idea of uniformity. And if we go to the final slide, I'm trying to drop the conclusions, and please change the slide if possible. Thank you. We see here that in our special legislation regarding the awarding procedure, that the Romanian legislator tried to respect all these principles which come from the directive and of the European law: transparency, adversarial right to defense, celerity. The provisions are okay, but they are not connected to the reality of the system. This is one real problem. Also, we have problems at the level of the legislation, because the provision I was talking about, which compels the judge to go in two steps proceedings, first to decide if the decision of the council is correct, and then to file a decision on the merits. It's something which doesn't go very well with the celerity principle. And if we're talking about the electronification, yes, I think it's a good method to reveal this principle of celerity. Of course, the transmission of documents and procedural acts that the authority files in the award proceeding are very well communicated and very quick, and we have the possibility to see and to know the content of these documents. But I'm always thinking about the costs of this electronification process. I was talking yesterday with one colleague from Poland, from Krakow, as I remember, and I asked her if someone thought about the costs in order to use the servers we need to stock this information, a lot of information, one of them. And the second problem with this electronification I see in this proceeding before the jurisdictional forums in Romania is the need of confidentiality, because this is a principle. How do we do to accomplish the idea of confidential information if we use the internet and if we use the sites and all programs, because all of this has to be sure, and in order to be sure, that goes to a lot of costs, I think. So this is not, in my opinion, a good thing to find in this idea of electronification. In general, the cost of the electronification, I think they are larger than we know and larger than we can even imagine. Thank you very much. If there are questions, please.
Thank you very much, Andrea, for very interesting but very, very long paper. We have delay now, so the last one paper in this panel, Joanna Maria Gabriela, a PhD lecturer, and her paper Offenses regarding non-compliance with the construction legal regime, czyli przestępstwa związane z nieprzestrzeganiem przepisów prawa budowlanego. Gabriela,
hi.
Where are you? Here.
I'm here. Do you see I'm trying to share this on the screen?
No.
You don't see?
Not yet.
How can I do? I did it yesterday.
Yes,
Maybe.
yes, but so can we? So should we share with your presentation or?
Yeah, you have an email. I send it
Yes,
to
yes,
here.
but so we should share.
Let's see if. Yeah, why not?
Pani Kasiu.
Tak, sekundkę, już odpalam.
Or maybe if you can show the port direction.
Maybe you are not able to do it because okay.
Okay. So did I do it?
So, pani Kasiu, to jest od nas, czy od pani doktor?
To już pani sobie odpaliła, bo mnie to
pani sobie
It is on the
odpaliła.
screen right now?
Więc ja jestem jak coś gotowa.
No, it's the same like yesterday. Presentation is covered by other screen. The same situation. Oh yes. Oh.
No.
We can see, but can you change the slide? Something cover sometimes. Yes, okay. Now
It was okay?
yes.
Okay, so
Okay,
you can see the slides.
I think
You can see also when I'm changing the slides. Can you see?
Yes.
Okay,
We can see.
Thank you so much.
Okay. 20 minutes.
So my presentation is about the criminal liability, of course, and then I'm trying to analyze the offenses regarding non-compliance with construction legal regime. And construction discipline in general is very strictly supervised in Romania, and non-compliance with the construction legal regime is sanctioned both contraventionally and criminally. From the point of view of criminal responsibility, the legislator has provided crimes both for the people who sign the technical documentation without having the necessary skills or competence, as well as for the people who execute the construction works without the necessary authorization. In the legislation regarding the quality in construction and the authorization of the execution of construction works, specific offenses are provided for non-compliance with discipline in construction, which, depending on the actual method of committing the illegal conduct, can be committed in conjunction with the certain offenses provided for the criminal code, such, for example, the destruction or crimes have as an active subject the public official abuse in office. We have two laws that specified offenses in this field. So the first law is the law number 10 by 1995 regarding quality in construction, provides as an offense the design, verification, expertise, realization of a construction or the execution of its modification without complying with the technical regulations regarding stability or resistance, if in this way life or bodily integrity is put in the risk more than once many people, and it's this crime is punished within prison, so it's considered very risky. So the imprisonment is from 1 to 5 years, and of course prohibition of certain rights. In the event that the act described previously produced one or more of the following consequences: loss of human life or serious injury of the bodily integrity or health of the one of or more persons, the total or partial destruction of the construction, the destruction or degradation of some installation or equipment, important or other particularly serious serious consequences, the penalty is higher. Namely, again, imprisonment from 3 to 10 years and the prohibition of certain rights. In both situations described previously, the form of guilt is in committing the act is direct or indirect intention. However, the Romanian legislation also provides for the possibility of committing the acts due to fault, not only to intention. And for the fault, a situation in which the spatial limits of the punishment, so for the fault, are reduced by half. Also, the legislation describe add to the criminal responsibilities some administrative, I would say, sanction for the person who committed these crimes. The crimes described above can be committed by any person in general, by the active subject being unqualified. However, in the situation where the acts were committed by a certificate or authorized specialist carrying out the activity in construction at the request of the criminal investigation bodies, the right to practice is suspended until the completion of the criminal investigation, or in the case, as the case may be, until the pronouncement of a final court decision. So basically, during the criminal investigation, the right of practice is suspended. The suspension of the right to practice was provided as a complementary section, considering the quality of the active subject and the existence of the potential risk that his criminal conduct would endanger the safety of the legal regime of construction in other situations as well. The other law who provides criminal responsibility is the law number 50 from 1991, but of course updated to the present, regarding the authorization of the construction of the execution of construction works. Whom also provides, as I said before, a series of offenses with criminal sanction, punishment with imprisonment, but not so higher, a little bit less, from 3 months. So we have also a very small punishment, 3 months to 1 year, or can be also with a criminal fine. So comparing with the previous sanction from the law 10 from 1995, in this situation, the punishment are much lower. The crime concern, according to the law number 15 from 1991, is the execution of construction, reconstruction, or expansion, repair, consolidation, protection, restoration, conservation works without a building or demolition permit, or with a non-compliance with its provisions, as well as any other works, regardless of their value, which are to be carried out at all categories of historical monuments provided by law. Monuments, complex seats, including their annexes identified in the same building or buildings. For buildings located in the monument protection areas and in the protected build-up areas established according to the law, or to construction with a special architectural or historical value established by approved urban planning documents. Also, another crime duties law is the continuation of the execution of the works after the order to stop them by the competent control bodies according to the law. And finally, the drawing up or signing the technical documentation necessary for the authorization of the execution of construction work, as well as the technical project and the execution documentation for other specific specialists than those certificate by an university diploma or by a diploma. This crime, it's we can also find in the law number 10, but a little bit modified. Other measures that can be added to the criminal liability. So the judge or the prosecutor not only apply some criminal sanction, punishment, they can add also other measures. So basically the court, through the decision by which is solved the merits of the case, can order inclusion of the work in the provision or of the authorization, so they can establish to become legal, or the dismantling of construction made illegally. This is the hardest one. The prosecutor or also the court can also order as ex officio or upon request the temporary stop of the execution of work through the criminal process. So basically through the whole entire criminal process till the court to establish a final punishment. They can also decide the temporary stop of the execution of the work. Who can notify the criminal investigation body? Basically, anybody, any person which is interested can notify the criminal investigation body, as well as the authorities. And regarding the authorities, we are speaking about the president of the county councils, the mayors, and the control bodies with the local and county public administration authorities, which has the obligation to follow the discipline in the field of authorization, the execution of the construction works within their administrative territorial units, and depending on the violation of the legal provision, they are obliged to address to the body's criminal prosecution. So basically, regarding the authorities, they have the obligation, in the case of violation of the legal provisions, to address to the body's criminal prosecution. The private person, they can do that only if their interests are can suffer. Also, for the works related to the transport infrastructure of the national interest, the control body designated within the Minister of Transport have the obligation to follow the discipline in the field of authorization, the execution, authorizing the execution of construction works, and depending on the violation of the legal provisions, to others to the criminal bodies. So this is the what I will touch in the articles, and because the time is short, I want just to jump to the questions and of course to debates. If somebody has any questions, or somebody would like to debate regarding the offense, regarding the non-compliance with the construction legal regime.
Thank you very much, Gabriela. So who has the question to our speakers? Don't be shame. Please, please welcome. Who wants to know something about legal law in Romania? Please. I have two questions, but I wait. If maybe someone. Okay. So I have the question to one to Amelia and one to Andrea Tabacu. Yeah. One question to Amelia, because I'm interested in this topic, this subject. Are the entities jointly tendering for the award of a public contract a civil partnership or other civil law entity, or they are separate entities which combine their potential? Because in Polish law we have the problem how to name this something like this consortium, and is it only is it separate parties or one party, like for example civil partnership? What is in Romanian law?
Usually in Romanian law, they are like a joint venture, separately partly, and one of them, they can be more, not just two of them, can be more, and one of them to be nominated like a principal one. And in the contract will be provided the responsibility of each of them, the profit and loss sharing, all these conditions under they will develop and implement the contract.
But have you law which regulates this kind of partnership?
It is the civil law.
The
civil code, which provides this joint venture, and the contract, civil contracts also. And in the tax code, it is something about the the terms of association without legal personality, distinguishing between the joint venture and also other form of association without legal personality. And this civil tax code provides the way how they make the declarations.
So because we have this kind of we haven't got this kind of regulations. So I was interested in Romania.
Yes, usually by a contract. By a contract where they declare the way how they are complete the work if the contract will be won.
Yes, but in Polish we have unnamed agreement. It isn't regulated by law. This kind of agreement. Only we have some acts which with this kind of agreements shows us, but there is we have no any regulation about this kind of agreement. Okay, thank you very much. And
I would like to complete, if it's possible, what Amelia says, and she's right, because we use the civil law, but also in the special law in the 98 from 2016, we have a provision which defines the economic operator, and it talks about any legal legal person of public or private law, but also about group or association of other persons, and also temporary associations. That means we don't need a document. They have an agreement between them. They don't form a legal person. They come to the awarding proceeding. They finish the contract after that if they win, and then they don't know each other.
Yes, but in Polish, in Poland, we have this kind of regulation. We have it's rather in jurisprudence and doctrine.
Not even the civil law, not even the civil law about this association.
Yes,
That means
yes, but
you have an old civil code.
yeah, no.
Where is it?
Code,
when is it from your civil code?
1964.
64. That's explainable because we have one from 2011. So
okay.
And this law about what Andrea was speaking about, 98 from 2016, is according the European directive to 24 from
yes, I know.
14.
But you don't have a law.
It is transposed.
Yes. So I just
you have to transpose
so
also the legislation.
I asked in connection with this directive. So we have transferred this direction to Polish law. Okay, and Andrea, I have the question. Yeah. Do you know how often do review proceedings and in the annulment of the public procurement contract and the award procedure is repeated? Do you know how often?
The same proceeding, the same.
Yes,
proceeding?
and next after annulment, proceeding is repeated. How often do you know?
That depends on the level of the proceeding, awarding proceeding, because we have if we have an important one, we can have many, maybe more than 4 reviews, because we win a first step and then the contracting authority change the documents or do something what the court or the council said, and then we go challenge again this against this new document and so on. I found it in my practice maybe more than 4 times in the same proceeding, and the proceeding went next year and they lost the money, the financial, because that ended at the end of the year. Okay. So yeah, we can have this, but this is an abuse as I see. Somehow only few of them they win after the 4 contests of the same idea. You see, the rest they are doing it only to not to respect the celerity. They only want to stop or to destroy even the proceedings.
Yes, because annulment in Polish. In Poland, it's rather rare situation.
Before the courts?
Yes, before the courts. It's rather rare.
No, we do have it. We do have it. We don't just reject the appeal against filed against the decision of the council, by example. We usually did the opposite.
Okay.
Yeah.
So it's opposite in Poland rather. In practice, of course.
In practice, yeah.
Of course. Thank you very much.
We too.
Thank you.
Okay. Has anyone questions to our guests? I can't see. So, Fabio and Maria. Maria is here. I can see.
Yes, I am.
Okay.
Good morning.
Hello. Good morning. Is Fabio here or not?
I don't see.
I can see him.
Not. Yes. I think he is not.
He is not. I can see him. So maybe let's take a break, maybe 10 minutes.
Okay.
10 minutes break, because we are after a long second panel, and maybe break, for example, 12:05, okay? 12:05, 7 minutes break, and we will back here, okay?
Okay.
Thank you.
Okay.
See you.
Bye. See you too.
Okay, let's start. I can see Fabio, so I will write to him if she is going to join us. So let's start third panel. Zamówienia publiczne i roboty budowlane w Portugalii, public procurement and construction works in Portugal. So Maria, could you start, because Fabio is out, I see. Is Maria
Yes.
here? Okay. So Maria do Rosario Anjos. Anjos, thank you very much. Professor from Lusofona University in Porto. And her paper Zamówienia publiczne w prawie portugalskim, public contracts in Portuguese law framework and dispute resolution rules. Have you got a presentation?
Yes.
Could you share with us?
Okay.
Do you know how to do it? On the top.
On the top, yes.
You have share in English. I don't know. You have English version. I think.
Know how to find my file. Oh.
You have to open first your presentation, and there you have to click share, and then share screen. I think.
Yes.
And I will write to Fabio.
Oh. Something is happening.
Changed.
Yes.
Oh, we can see. Okay.
Can you see now? Yes.
Yes.
Okay.
We can see. So Maria, floor is yours. Please.
Thank you. First of all, good morning, everyone from Portugal. It's a pleasure to be here with us, with you, and participate in this conference. My team is about public contracts, and as probably you know, this matter is regulated by European Union directives. So in this moment, in all European Union countries, the basis of the public procurement regime is common. But of course, when we create law with a basis on directives, European directives, of course, that we always find some differences between the regime in each country. So the point of this matter in Portugal is that our code is from 2008, and until now he was changing every year. In 12 years, 12 changes. Okay, the last was in 2022, but the point I will share with you. Let me see. Yeah, I think is that. Okay. Okay. Sorry, I forgot to put the photo. Bon. The Portuguese Public Contracts Code was published and into force in 2008, as I said, and by the European directives basis. But it was the first law the first law, brought together a set of provisions that govern the procedures for the training and most public contracts, because until then, the Portuguese regime of public contracts was established in a few articles, actually 6 articles of Administrative Procedure Code. So it was not a big thing. And all these problems were resolved by the general theory of contract. So, since 2008, by imposing by European directives, we have a code, a specific public contracts. And in 2017, yes, but it begins the application in 2018. The peculiar, I think it's a peculiar solution that was introduced in our code in this article 476 is a possibility to resolve the dispute in public contracts by recourse mandatory arbitration, not any kind of arbitration, but an institutionalized mandatory arbitration. What is that? Because, as you know, arbitration is by nature something that is voluntary, not mandatory. But this kind of solution to dispute resolutions in this matter imposes an institutionalized mandatory arbitration. So that is the peculiarity of our regime. But not in all cases, okay? Let's see. The solution introduced is to give the public authority the possibility of imposing in the notice of tender the resolution of disputes arising from the public contract using an institutionalized arbitration center chosen by the contracting public authority. It means that the public authority has the possibility to choose if he wants or not the arbitration to dispute resolution. Public authority has the possibility to choose the center of arbitration. And if, because the article demands that, if the public authority chooses this way of dispute resolution, the private, all the corporations interested in the public contract must be, vinculated to this institutionalized arbitration center. That's why we call this solution a mandatory institutionalized arbitration. The freedom of choice is all in the field of the public authority. This way is guaranteed the transparency of the arbitral decision, the arbitrators involved, and the accessibility to the jurisprudence in public procurement. Okay, this is the fundamentation, this is the principles that our law chose to persecute, because until 2018, the solution for dispute resolutions in this matter was almost in all cases a recourse to arbitration ad hoc. And arbitration ad hoc has two problems. First, is not transparent, because the secret of decisions is not good for a matter as public procurement. And the second problem is that arbitration ad hoc is so, in terms of costs, is something unacceptable in the public field of actuation of governments. So, does this possibility constitute true voluntary arbitration is the first question. Well, the answer is partially, because the public entity, as I said, can choose whether or not to subject dispute resolution to institutionalized arbitration. But the contracting authorities, if they submit proposals to the tender, are mandatory bound to this arbitration. So the freedom of choice is in the field of public authority. You can choose your referee, but that is your only option. Okay, if they go in the game, if they go, they are mandatory vinculated to this solution. Therefore, it's not a voluntary arbitration, only partially, and the contracting company have no choice. If they want to contract, they must be obey the possibility chosen by public authority. Is the recourse to arbitration courts with sufficient transparency, exemption, and accessibility guaranteed at competitive costs by small and medium-sized undertakings? This is another problem, and this legal solution was, I see, quite critical for some sectors of the market, because the small and medium-sized undertakings says, well, we don't have the financial conditions to go to an arbitration center. In my opinion, this is not a problem, because until this solution, when public authority choose arbitration ad hoc, of course, it was a negotiation with the parts involved. Now is not a negotiation, because it's a possibility of public authority to choose or not the arbitration, institutionalized arbitration. But this kind of arbitration is not so expanded like arbitration ad hoc. And most of all, the transparency of decisions are absolutely fundamental, because all money we spend in this field are public. So we must show to everyone how, with who, and when we are spending the public resources. So, in my opinion, this was a good solution, as all legal solutions, not idealistic, but a good solution, because arbitration ad hoc was a problem, and still is a problem, because in Portugal, arbitration ad hoc was so disseminated in this field that some stakeholders don't see this solution as a good thing, because, you know, the business of ad hoc arbitration maybe is finished. So that's why I think in a public sector so important as public contracts, we must above all guarantee transparency, and transparency of everything. Transparency in public procedure, of course, transparency in the conditions of that public procedure, and transparency in case of dispute resolution. We must know the sentencings, the decisions, because if we don't know, we cannot understand who did not the right thing to the public interest. And that's why I think that this sector, public contracts, are very special. And this solution actually is a meeting point between the principles of voluntary arbitration, because public authority can choose. If public authority don't choose this way of dispute resolution, of course, any kind of resolution will be decided by our courts, administrative courts. If public authority choose, it's true that the corporations cannot choose another way. They are mandatory, vinculated to the option of public authority. But the great point is that we win much more transparency, and in this moment, since I see 2-3 years ago, we begin to have accessibility to the sentencings of dispute resolutions in this matter, because arbitration ad hoc is absolutely secret. We never know how and why our state, the government, lose the process. And we are talking about millions and millions of euros. We are talking about a sector that is most of the financed by European Union, you know, and is quite important to guarantee that transparency. It's a controversial solution. We are not all administrative stakeholders are not, are not agree with this solution, as we must say. But the truth is that the traditional, I'm trying to say this in a simple way and friendly way. So the traditional administrative stakeholders that in all cases of arbitration ad hoc was chosen as arbitrators are against the solution. I don't need to say why, because I think all of you understand that this business is now not so good as before. The others, okay, are, I see, much more according with the solution, because we understand two things very important, and I'm finished. First, in this field, we need some speed on decisions, because the traditional justice in Portugal, the administrative justice in Portugal is so slow that the foreign investment and the growth of the country is, of course, in second plan, and it is not possible. We must guarantee that justice is efficiency, so or is efficient. So the recourse, the arbitration as a way of dispute resolutions is just another way. So, but it's very important because the decisions are usually in 6 months we can have the decision of the dispute resolution. So this is very different that we wait 10 or more years for a decision in first instance of an administrative court. So this is another way, is not the only way. It's mandatory if public authority wants. So it seems to me that the transparency and accessibility to the decisions and create a public contract market more fair for everyone is the most important thing that this solution guarantee. And last point is that this arbitration justice is not expensive. The law of institutionalized centers is mostly the same of the official costs for a judiciary procedure, okay, process. So it's the same cost of a process in administrative court. Well, that's it. If you have some questions, I would like to say if this solution is very are being the principal choice of public authorities. We don't know yet, but I think that arbitration ad hoc was so interest in the market that they are yet the preference of public authorities and corporations. And it means that we must put another question: why? Well, if you have some questions, I will like to answer. And thank you for your attention.
Thank you very much, Maria. Andrea, I can see you have the question.
Yes, I raised the hand. If it's possible to ask something. You're talking about an arbitrarial proceeding which is compelling for if the authority wants, but the decision delivered by this arbitrarian forum or panel, is it possible to be challenged before a judge from the judicial system, or is final?
No, it can be a recourse to the superior court, okay. Not the first instance, but if we have a conflict of decisions between a decision of arbitration compared with another decision before from a superior court. It means if the arbitration court decides in another way, yes, we can have an appeal.
That means the arbitrarian decision is final. You cannot go before the judge against this decision.
In part, yes. We have a possibility to impugnate the decision if they have something of nullity or invalidity. Okay, yes, that is impugnation. We call and it is done to the second instance a superior court, okay? Yes, we can impugnate and we can appeal. If in case of conflict of judgments between arbitration decision and court decision, yes.
Okay.
If not, the decision is final. Yes.
Interesting. In Romania, all the arbitrarian decisions are able to be challenged before the Court of Appeal, and then we have an appeal against the decision of the Court of Appeal before the Supreme Court.
Yes, in Poland the same. We have the same.
It's true that we have a certain reason of nullity, I mean legality, the problems we have to challenge before the judge, but usually we have a general reason there which says something about the merits, and I can challenge that decision, arbitrary decision on the merits too.
No, in Portugal it's not like that. Actually, we have administrative arbitration and tax arbitration. I think we are the only country in all European Union we have tax arbitration. And actually, I'm also a judge in an institutionalized center of arbitration in tax and administrative arbitration. Okay.
Okay.
This center is different from any other because it's only one with competence for tax arbitration. In administrative arbitration, there are 2 or 3 centers in the country with competence to arbitration in administrative field, okay? And these kind of centers, institutionalized centers, are supervised by the Superior Council of Administrative Courts, So there are a connection with the administrative and tax courts, from the judicial, the judicial power has a kind of, I don't know how it says, okay, but superintendence.
That means you're not independent as an arbiter. In the arbitrarian courts are under the administrative judicial courts, which are part of the judicial system.
Yeah.
Okay. Interesting.
No, we are independent because we have a list of arbitrators that some of them are lawyers. Others are professors, as me. I am professor and I am lawyer too. But since I am judge in tax arbitration, I don't do nothing in the tax field as lawyer. Did you understand? As lawyer,
you don't practice as a lawyer in tax field.
Yes.
But you deliver solution in this field.
Yes, it was my decision. Okay. Because this kind of justice is very important to the development of the country. If the country needs foreign investment, we cannot say to a foreign investor that if they have a conflict with our government, with our in our country, he must wait 10 or more years for a judicial decision.
What?
Yes.
Oh, that means you're really unique.
So, as I said, it was a solution. It was a solution imposed by European Union in 2008, when Portugal was negotiating another plan of financial support, and 2 years after, Portugal needs an international rescue, okay? Because we was in default, financial public default, and European Union, all the International Fund, Monetary Fund, ask to our government, why you are in default if you have so many and many millions of euros in the courts? So discussing in the courts, if you can resolve this, maybe the government have much more money, you know.
Okay,
but
okay.
It was a big problem. In 2011 in Portugal, we had 45 millions, 45,000, okay? 45,000 of process waiting for a decision. So that's why we find, you know, a meeting point. This is arbitration, and it works with speed and with less formalities, so the decision happens, okay? But this arbitration is supervised by the judicial courts, because the Superior Council of the Superior Council of Administrative and Fiscal Courts has the possibility to change our decisions and to see who is arbitrator, because we must buy a serious selection to be arbitrator. That's why in my case I'm a lawyer, but not in this moment, not in tax, because in tax I am judge in the arbitration center.
Okay.
It's
an incompatibility somehow.
Yes.
And excuse me if I continue, is it that number of cases before the judge, 45,000 you said, did they have the possibility to leave the courts and go to the arbitrary? Because here in Romania, if we catch the judge, as we say, we cannot leave there and we cannot go in the parallel proceeding of arbitrarian.
Yes, we can. In Portugal, the situation was so bad that in the first law that introduced this kind of arbitration in 2010, it has a possibility that process with more than 2 years waiting for a decision, but without any kind of impulse, processual impulse, you know, they are stopped for more than 2 years. All that process, if one of the parts wants, he can require the migration. We call that migration of the process to the arbitration court. Yes.
Okay, thank you.
And now I must say that the numbers of pendencies, I think we can say that in English. So now the number of process in the administrative courts, judicial, are much
lower.
Yes. So the system is more efficient. That's no doubt. Okay, much more.
Thank you very much.
Thank you very much, Maria, for very interesting paper. Have we any questions to Maria?
I have to say goodbye to everyone because I have a class.
Okay, so
in our PhD.
Has anyone question to Maria at the end? No. So thank you very much. Thank you very much, Maria, and goodbye.
Thank you. Goodbye.
Thank you. And we have the last professor Fabio Vega. Welcome, Fabio.
Good morning. Good morning.
Hello.
Good morning, everyone.
Professor from the Lusofona University in Porto. We were waiting for you. So the last paper this day and in this conference is partnerstwo publiczno-prawne w świetle analizy prawa gospodarczego, public-private partnership under the analysis of business law. So Fabio, floor is yours. Please, 20 minutes.
Thank you, Professor Tomás. I try share my PPT, my PowerPoint.
We can see your presentation.
Okay. Good morning. I would like to thank the organizers of this event for the invitation. I would like to especially thank the Professor Tomás Sensilo for the invitation to participate in this panel. My grades to the other policy colleagues, especially to the dear colleagues who have already been to our university, Lusofona University in Portugal, the Professors Beata Zaluka and Professor Igor Zolinski. My thanks for this collaboration.
Zaluka Fabio is the best.
Yes.
In Polish, rather Załucki.
Yes. I will go to results in December.
Yes, okay.
Okay, and today I'm going to discuss the theme. My theme is leaderships in public-private collaboration, because I chose this theme because my scientific area is business law, and I try to talk about the theme in the leadership, in the collaboration and public-private. Public-private partnerships refers to those cases in which a public administration commissions a private law entity for a specific period to design, construct, and operate infrastructure or some of these services, in addition to financing them. The challenges faced by public administrations in the 21st century, characterized by the globalization of the economy, the demand for accountability to society, and the need to meet new demands with an optimal quality standard for citizens, compel us to rethink the public-private partnership model and its functioning, moving beyond preconceived ideas or strictly ideological viewpoints. Today, the right to good governance is the paradigm on which the role and justification of public powers should be based, with these powers assuming the role of guaranteeing quality and equity in the provision of public service to citizens. Through public procurement, public authorities engage in a policy of intervention in the economic, social, and political life of the country. We move directly into the contract execution phase to ensure quality control and the correct satisfaction of public interest. Public governance.
Fabio, sorry. Could you change the slides?
Yes, I changed here, but
okay.
And I don't know because no change for you. I try.
It had changed. It has changed now.
I changed for me, but I don't know because you no change.
We can see. We see now fifth slide.
See, my slide now is 5.
Through public procurement, public authorities, and etc.
Yes, public governance in design.
Yes. This.
Okay, number 5. And the public governance in the design of public-private collaboration requires first and foremost the correct identification of the needs and solutions to be addressed through procurement, as well as the risks involved and their proper distribution among the parties involved. It's necessary to overcome formal inertia to pay attention to drifting, a well-planned and strategic tender document that precisely regulates the possible contingencies during its execution and, above all, encourages compliance in preserving social rights. The leadership in public-private collaboration. Now, let's move on the main topic of this talk, the reflection on the necessary leadership in PPPs, public-private partnerships. There are specific characteristics from both the public and private sectors that are essential for leadership. Below, we added the peculiarities of collaborative leaderships as the type of leadership most suited to their directing and managing PPPs. Behind a PPP, there are many people involved, and depending on the type of project, it can take anywhere from several months in the preparation phase to several years. This means we are dealing with a highly costly process, where proper planning with a clear strategic vision followed by effective management can lead to significant cost savings for the taxpayer or user. Leaderships in PPPs requires a great deal of organizational development skills, with PPPs leaders clearly needing to interdisciplinary profiles with considerable experience. We know the importance of leadership in both the private and public sectors. See, for example, the Antonax 2022 and Ospina 2017. However, the role leadership must play in ensuring great success in PPPs is still to be fully addressed, although anyone with experience in PPPs can confirm this a greater or lesser extent. Importance of leaderships in PPPs. Why should we talk about the leaderships when discussing PPPs? In general, the results of the study by Jimeno Fellow et al. 2018 showed that the role of leaders in PPPs is very important in the decision to develop a PPP, contrary to what was previously argued in the literature on PPPs. It is worth noting that the study did not measure the quality of the PPP, but rather whether a project was developed in collaboration with another sector or instead decided to be carried out within the same organization. We also know that many factors have been linked to the success of a PPP. For PPPs to succeed, extensive negotiation and consensus building are required to develop a common understanding of the project at each stage among the main stakeholders. It's also common for contracts to include requirements that address to concerns of a wide range of stakeholders, with debates taking place during the preparation, contracting, and management or execution phases. However, the most important question we face in whether leadership is truly relevant, not only for the decision to collaborate between actors, but also in determining whether such collaboration will be successful. In a PPP, where the parties are highly interdependent, yet highly antagonistic, successful collaboration process can occur if the right leadership is in place. For example, in a PPP, the different actors may not share the same public values, such as concepts of integrity and good governance. Public managers may be restless and imaginative in their search for public value, helping to discover what government can do create public value through the PPP. While private sector managers may be focused on project efficiency and the pursuit of private profit. In short, the figure of a visible leader is necessary in a PPP. Leaderships that generates more leadership is required. As Professor Emeritus at Indiana University in USA, Roberta Granoff argues, the management teams involved must also be engaged in leading the collaboration and maintaining a fluid relationship with the direction of the PPP. Thus, leadership is needed that enhances the teams. This is the opposite of heroic and individualistic leadership, which can have serious consequences in project management, especially when those leaders abandon the projects. Therefore, leadership that is generous with work teams and institutionalizes good management practices is essential. Leading in the public and private sectors, the path toward public-private collaboration. In the public sector, it was not until the 1990s that scholars began to see a broader role for a leadership in public management. Ospina 2017. The public manager had the potential to be an active creator of public value that is a leader with discretion, advancing, shaping, and directing, with conviction, a complex policy implementation agenda. The creation of public value must be at the heart of the PPP. It is important to share public value in both the public and private sectors of the PPP. Bryson, Crosby, and Bloomberg have argued that leadership is one of the crucial means by which public value is created and preserved. However, as Ospina suggests, the movement within leadership studies must shift from leadership-centered approaches to system-centered approaches. This perspective can help develop more comprehensive models of public leadership at a time when public managers are expected to practice leadership and when businesses are increasingly managed through service delivery networks and partnerships. Collaborate between the public-private sectors is at the core of such networks and alliances. At this point, it's worth recalling the work of Anderson, 2010. In it, various aspects of management and leadership that are relevant to PPP are identified. First, public managers with a leadership style oriented to change tend to use intuition more intensively when making decisions and have a high achievement motivation profile. Private sector managers, on the other hand, are predominantly relationship-oriented. They are also intuitive in decision-making and are motivated by power. Both public and private managers are characterized by intuition as their primary decision-making function. Anderson presents three explanations for the difference in leadership behavior between public and private sector managers. The first concerns organizational difference that led to difference in behavior. In other words, managers behave differently because they perform their roles in different contexts. The second has to do with career or vocational choice. In this sense, Anderson proposes that public sector managers are more likely to adopt a participative leadership style that help to satisfy the various stakeholder groups with which public administration typically engage. Finally, the criteria used by organizations to promote individuals into leadership positions may provide another explanation for this difference. However, for a better functioning of the PPP, leadership must help reduce the stereotypes that the private sector holds about the public sector, and vice versa. As political scientific Barry Bozeman stated, it is important to recognize that the public and private sectors are fundamentally different in less significant aspects, but they can function adequately within a PPP. Thank you for your attention. Dziękuję.
Wow. Proszę bardzo. Thank you very much. Thank you very much, Fabio. I'm very happy you can say dziękuję in Polish. Obrigado.
Obrigado, dziękuję.
I know this word. Okay, thank you very much for your very interesting paper. Has anyone a question to? Oh, Maria is with us. Okay.
Yes, now in the university, so I have a few minutes. I come back.
Okay. Okay. I thought you let your students go home.
Yes, a few minutes.
Okay. Has anyone a question to our guest from Portugal? Maybe.
This tema is very theoretic, no? It's my choice of tema is theoretic because my position in study is private law and in business law, but the governance in public governance have typical models, no? For example, the public value is very important in the relationship between the sector private and the public. In this paper, I try to show these studies, those studies, and that the doctrina explain the public values is important for the collaboration between private and the public sectors, no? PPPs. No?
Can I
is the center of the discussion.
Can I say a thing about your presentation? In fact, in public research and in public sector in general, jurisprudence, doctrine, the stakeholders with justice. In this field, I think that in this moment, the most important topic is the good governance. Because this theme about PPPs in Portugal was a big problem to public finance. It was not transparent, and the government spent so many millions of euros in PPPs that was not fair, was not balanced. Some contracts doesn't have any clause for guarantee the government in case of some kind of problem with the project, okay? The contracts were made to guarantee the corporation, not the government, not the taxpayers, as you said. So now we are trying to recover the PPP as contract to public projects, but we must have some requests of good governance, the values you said, okay? Because the first experience in Portugal was a disaster. Financially, was a disaster. Yes.
Okay. But is it a normal, common situation in Portugal, of course, if for contractors to bind jointly for a public contract for tendering the public contract? Is it a common situation, or rather they are going to tender separately? Do you know? Because in Poland, it's rather common situation that the separate participants joined and they are going to get contract together. So is
it means a consortium.
Consortium, yes.
Yes,
in
yes,
Polish,
it's common in Portugal too. Yeah.
Because it's normal. It's common situation in Poland. Consortium for the public procurement to get a public contract, of course.
And the good thing is that the public contracts must be international. So any corporation from any country of the European Union can play the game. So it's much more fair. And our government in the last 10 years, because we were in default in 2011. Yes, 2011. Yeah. 11. So in the last 10 years, the government has saved much money because the contracts are well made, are much more fair, much more transparent, and the international procedures are absolutely different than a national agreement. You see, because less corruption, and I think it's
more
transparent. Is the point. We don't want to talk about it, but this is the point. This is the point in arbitration, ad hoc. Of course, they are against the solution I present because they were in the game, and some arbitration process were millionary.
Yes, of course.
Arbitrators, okay, as in international arbitration, but in private corporations, there's no problem. There's no problem. If they pay, they want to pay, and it's their money. In public affairs, I think is a big problem. Yes.
Yes, of course. Okay. Has anyone question to our guests?
I don't have a question, but I just invite myself in Portugal to see the truth because I want to compare it with ours.
Yes.
If we are talking about two sides, PPTs inside for national problems and international contracts when we are talking about the EU. So it's very interesting and it must be searched. Thank you.
Yes, I think so. Come to Portugal. Yes.
I already invited myself. Thank you very much.
You are invited.
And we are waiting for you in Romania in May.
Very beautiful city.
And we should make a collaboration.
Oh, collaboration is very
A
important.
joint venture, maybe not without a legal person, but just a joint venture for a conference or something else in order to see each other face to face. It would be better.
I think
So we are
it will
waiting
be
for you
very
in Romania. Okay.
Yeah.
Okay, thanks. Has anyone any questions? Any question?
Now I have to go.
Okay, Maria. Okay. So
We have to go to.
I think we are going to finish our conference. Ladies and gentlemen, I can say, on behalf of all three organizers, my university, European University of Law and Administration in Warsaw, Maria Curie-Skłodowska University in Lublin, and Kujawy and Pomorze Academy in Bydgoszcz, and of course authorities of these universities. So I would like to thank very much for all speakers who, in my opinion, delivered us excellent papers at the really, in my opinion, in the really high level. I hope that I'm expressing not only my opinion, not only my point of view, but the opinion of all conference participants. I think it's a very important. We are able to learn to know about public procurement solutions applicable in other countries. In Poland, we had 4 countries, and Ukraine, I hope it will be on in article. I think such an exchange of legal ideas and experiences, of course, is extremely valuable. I believe that we learned something from different legal systems, because I believe, of course, it is impossible to consider whether some legal solutions in this matter from our countries, but I think we can use some of solutions to develop our regulation. I hope so. This kind of conference will continue as they are extremely because they are extremely developing. I think. Many thanks also to all the audience or participants, not only speakers. So I hope they expressions after this conference are the same as mine. I hope they will have only fond memories of this conference. Thank you very much. As I said, I will write an email for all of us, for all of speakers about with details what next. Of course, the most important thing, limit data for articles. So thank you very much for everyone, and I hope it wasn't our last joint conference, cooperative conference, joint venture, as Andrea said. Thanks a lot and goodbye. Thank you very much.
Thank you too. See you next year in Romania, first in May, okay? All of you. Okay?
Do you know the data?
It's in May. Anyway, it's in May.
I know
the data will come in December, because only in December we decide important things for the next year. But we will keep, we will send you the information. And also, Professor Fabio Vaiga, if you are, if you have the possibility to choose a moment in May next year, we invite you in Romania, because we have to develop our relationship that starts now. Okay?
Fabio, I can see this is wonderful conference. Really.
Yes.
Really.
He's already member of our editorial board of the journal, so he can be also to the conference.
Yes, of course.
We were waiting for you.
Yes, definitely. Thank you very much.
Thank you very much.
Thank you too.
Have a good day.
And see you. Thank you again. Bye.